important to have a plan and understand what your goals are.
In fact, my camel out there is suffering right now with a broken back.
So I actually found Pepe when it was only a couple of hours old, and I'm like, oh, this is a funny meme.
Oh my god.
Yo! Who is this Degen?
The old man is swing trading over years at a time. And it's like, that's where the real money is made.
The answer is a permanent loss. With single-sided staking, you don't have to worry about impermanent loss.
If you're aware, if you're disciplined, you can hone that into further financial growth.
Financial freedom, to where you can actually live life and not have to be constantly living paycheck to paycheck. I mean, that's the ultimate goal, more or less, right?
Ladies and gentlemen, boys and girls, crypto degenerates, ducks and squirrels, welcome to this here.
And we'll cut out. Ladies and gentlemen, boys and girls, ducks and squirrels, and degens of all ages. Welcome to this edition of the stream. We are doing a special Shakespeare in the Park, if you will. Will has been so generous to acquire a copy of the transcript for us. Well, it was actually from the Pulsechain Foundation, too. So shout out to those guys first and foremost. But yes, today we are going to be reenacting, or pretty much just reading, the transcript, and we'll have the transcript live up on screen. Today, I am Zenith, but I am also representing the Richard Hart legal team. We have Will representing the SEC legal team, and we have a very special guest with us who will be presiding over all of the proceedings going on. So, Miss Judge, who are you? Where might have we seen you before?
Oh, you're muted. Oh no.
There you go.
Yes, that would be helpful. Yes. I normally go by AWildSJ, as you can see here in that little thing. Longtime community member and big fan of Richard Hart. You may have known me from my previous work reading Sci-Vive, a book by Richard Hart for the world, to make the world better, as well as his other book, 15 Ways to Fix the World, because that's what he's doing every day, whether you know it or not. I'm team win, team Richard every day. And also one of the 3 members of the Pulsechain Tour team, who have benefited greatly by these guys here, these degens. You guys are super helpful. And as well as a founder of fanforge.xyz, which is a blockchain. It's a publisher for movies and content. It's actually been really interesting recently, because what we've been seeing on X with, especially I think Coffee posted something and someone else posted this transcript, right, is now published on the blockchain. So FanForge is similar in that they're doing that for media and for comics and possibly for Sci-Vive. That's kind of something that I'm trying to get done. But that's a little bit about me and my background and how I know these crazy kids.
Much appreciated. By the way, I think the best elevator pitch I've heard for FanForge is it is the Steam platform on a blockchain for all sorts of entertainment, not just games. Could be movies, audiobooks, short stories, anything else, and it's a way to have some sort of digital collectability and interaction with the IP itself. So I'm very excited for it, and I believe there's actually a special event happening this Friday at 9 p.m. Eastern Time. There's a Founders Pass that's going live, so if you're interested in that sort of thing, go check it out. What? Oh.
Delayed. 2 more weeks.
Oh.
Oh, no.
Classic 2 more weeks.
Yeah, we're trying to get some more eyes on it, some more information about it out there. And because here's the thing, this is not, while it is being built, it is something that is built on Pulsechain, and we are using the Pulsechain blockchain to immortalize this content. It's not, there's no token, right? There's no coin involved. There's no, like, this is also not an NFT platform, right? While NFTs are involved, it's not like, we're not trying to shill NFTs or shill a coin or anything. So we're trying to get more traction and more eyes and more information about it out there. So people who are collectors, right? Like, you love comic books, like this is your thing, or you love this one movie series and you follow it and you've got, or like Game of Thrones, you name it, right? Like, fandom is a thing and people love being fans of something, right? And like, that's something that people find common ground on. So anyways, long story short, yeah, we're delaying it a little bit to get more info out there.
All good. Fair enough. I'm sure there will be many more streams about FanForge over on Discord Syndicate, where I think folks can find you sometimes, right?
Yeah, absolutely. In addition to all that, I also am RG3's executive producer and assistant in life in terms of what goes on with that man and everything he does. So that is definitely where you can find more of that content. And we're going to try and start building our own base on FanForge. Like we have a YouTube for FanForge as well, so you can check that out.
Perfect. So cut off my man at the beginning because we were having some technical difficulties, but everyone knows that a movie or a story is only as good as the villain. So let's introduce our villain for today, Mr. Will Stevenson. How you doing, my man?
I am doing fantastic. Thank you for taking over. I didn't realize that my intro cut out there halfway through, and I went through the whole. I was going through the whole thing, and then I was like, "Wait, why is Zenith talking right now?" Because you started coming into my headset, and I was like, "Oh shit, my internet must have cut out." Right now, I'm up in the beautiful mountains of New Hampshire in my house up here that I'm never at, but it's super awesome, super fantastic. I'm super stoked to represent the bad guys in this here equation. We're gonna be reading through this entire 70-page document from the Richard Hart team, and I'm super stoked. It's going to be awesome. For those of you at home who don't know who I am, my name is Will Stevenson. I'm an iron worker. I travel the United States building TV towers and stuff. And in my off time, I like to talk to assholes such as yourselves, you guys in the chats, you guys on the panel, and all the other fantastic, wonderful Hexicans that I meet all over the place. If you guys are Hexicans and you want to meet other Hexicans, then what you need to do is you need to go to bit.ly/hex_meetup and go hang out with Hexicans. But that's not important right now. What is important is getting on with this transcript and talking about what's going on over there in the SEC and in Richard Hart's legal team. But before we do that, we got to roll through some of the very best part of the show. We got to go through chat motherfucking shout outs where we recognize all the folks at home who are doing such a fantastic job interacting with us live. Whether you're catching us on the replay or whether you're catching us on the live, we appreciate you all no matter what. So let's see. Mrs. Producer. Oh, I see we have some. I'm pretty sure that we're on YouTube right now. We are on YouTube. Excellent. Mrs. Producer, if you'd be so kind as to pull up our first chat shout. We've got first of the night from the one and only Mandingo. I guess it's actually afternoon or evening, but the one and only Mandingo. He's coming in with the fire. Good to see you, Mandingo. Shout out to you, sir. Glad to see you are here with us. Next up in chat shoutouts, we have none other than our very own super fun and awesome Kenturian54X. Button smash that like. You're absolutely amigo. I need all the folks at home to go ahead and button smash that like. And oh my goodness, that freaking sparkling water is getting to me. And we're going to have a good time reading this thing. Next up in chat shoutouts, we've got none other than Funk Master Hex. Ladies and gentlemen, good evening. Good evening to you too, sir. And as always, he's got the little drink at the very end. Glad to see that you're here with us, Funk Master Hex. This is going to be awesome. Next up, we've got our very own, the Ascending Man from the Degen Roundtable. You guys know him as Nate McGettit. He is looking forward to this hearing. It's going to be awesome. It is going to be fantastic. Glad to see you're with us, broski. Welcome, welcome. I hope I'm not cutting out right now because I see that everyone's cameras are resetting. Zenith, am I still rocking and rolling live? Have I missed anything? Okay, sweet. We're still good. Next up in chat shoutouts, we've got none other than Mr. Gabriel True DeFi. Shout out to Gabriel. He was out there at the event. Super duper fantastic. But he says 27 minutes until court's in session. Gabriel in Kansas City says, pay attention to the judge. She is purposefully boxing in the SEC to justify the dismissal decision she has already written. I hope, with a little smiley face.
The theory. I hope it's a good one.
Yep, I think that it's I am very greatly invested in that theory as well. So it's going to be excellent. Thanks for joining us, Gabriel. Good to see you. If any of you folks are ever over in Kansas City, then you need to hit up Gabriel and go hang out with him because he is nothing but fantastic to chill with. Next up in the chat shoutouts, we've got our very own Dace Northal. Let's go! So fucking pumped for this. I agree, amigo. I threw in the fucking because it seemed appropriate. So pumped for this. Good to see you, Dace. Welcome, welcome. This is going to be a good one. After that, we've got Mr. Gains by Casey, Replay Gang. After I get out of work, and fire emojis. Good to see you, Gains by Casey. Shout out to this gentleman, another IRL friend as well. I'm super stoked, and you're going to love this Replay Gang. Excellent. After that, we've got no one else other than my brother, Samuel Stevenson. Look at those trusses. Yes, I have a beautiful house with beautiful trusses. I don't know if they're load-bearing or not. They might be decorative. I haven't tried hanging from or anything yet, but yes, there are some beautiful trusses. Thank you, Sam.
I do believe those are load bearing based on the design.
Yeah, I mean, they very well could be. I see a single nail in them, so I don't really know. But
maybe
I'm
not.
not gonna.
Then. Never mind.
I'm not gonna test them. Hey, they're working. My house is up. It's been in existence since like the 1940s, so I think it's okay. But yes, shout out to my brother. He teaches people a lot about how to build houses and how to design things. He's got a channel, Rapid Designs, as well as Bungalows for Bachelors. Y'all should go check it out if ever you get the opportunity. Next up in chat shoutouts, let's see who we've got. We've got Luna C Point. Hey, gang, what's up? What's up, Luna? Good to see you as well. She's got the little heart emoji. A classic Degen Roundtable connoisseur and aficionado in the Hex space. Good to see you, Luna. Welcome, welcome. Glad that you are here. After that, we've got Robert online. Robert, an IRL friend. He was at the Richard Hart meetup himself. Good to see you, Robert. Welcome, welcome. We're going to do our very best to read these proceedings out as accurately as possible. And, maybe with a little bit of embellishment as well. But good to see you, broski. He was at the hearing, and he's a super cool guy. Y'all should check it out. And if ever you're in the area that he's at, go visit him and say hi. After that, we've got Mr. C3 Works. Will, I hope you practiced squirming if you're the bad guy today. I'm going to be the best bad guy, Bill. It's going to be awesome. For those of you guys that don't know, C3, he's one of the developers of the actuator protocol built on top of Hex. So glad to see that you're here, C3. And the SEC did quite a bit of squirming at the trial. I'm hoping to make this fun and awesome for everybody. Next up in chat shoutouts, and my God, we've got a lot of chat shoutouts. Pulsechain, altcoin talk, 9-inch. Oh, nope. Mrs. Producer, take that one down. Nice try, amigo. Get out of here with that crap. Anyways, no more attention to you. Archie S, evening, gents and SJ. Evening to you too, Mr. Archie. Good to see you. This is another gentleman who was there at the hearing with Richard Hart. Shout out to you. Or, excuse me, this guy was at the Pulsechain conference. He didn't have the he wasn't at the hearing, but man, this guy made the Pulsechain conference freaking awesome, and he was super cool. He was the one that actually won. He won the poster that we raffled off in the beginning. The Richard Hart team, they developed a timeline poster that's like, I don't know, fucking 3 foot by 2 foot or something like that they used to present to the judge the alleged timeline that the SEC brought forth. I'm going to actually show you guys a picture of it here as we're going through the proceedings, but he won it and he decided to gift it to RG3 himself. So shout out to you, Archie. Good to see you, brother. Or excuse me, I was Arthur. Archie, Arthur. I'm not sure. I'm confusing people. So shout out to Archie and also shout out to Arthur. Wherever you guys are, glad to see you here in the chats and welcome to the stream. Next up in the chat shoutouts, we've got Pulsechain Tour. We love your banner. Thank you, Pulsechain Tour. This is the best banner. You guys should check out the 369 Pulsechain Tour right now and use promo code DGen at checkout to get 20% off of your tickets. I believe, SJ, if I'm not mistaken, that we have the most used promo code for the Pulsechain Tour. Is that am I
Are we still number one?
I don't know. Pulsechain Tour would have that information.
Oh, that's true.
Right,
Yes,
right.
that's true. Yeah, Pulsechain Tour would have that information. If that might be one of the other 2 members. So excellent. Well, shout out to you, Pulsechain Tour. Glad to see you, and welcome to the stream. I hope that we can entertain you as well as inform you as we read through this stuff. What's up, SJ?
We're on that topic real quick. That code is only good until the 15th of November. So you've got like another 10 days left-ish to use that. Well, I mean, it's still good, but the 20% goes away after the 15th. So excellent.
20% off until the 15th of November. So get those tickets, ladies and germs. Excellent. Next up in the chat shoutouts, we've got Kaisa or Kasia. I don't know how to pronounce that. I still don't know. But shout out to you, sir. You make some excellent clips on Twitter. I always love going over to your channel and seeing what Kasia's got going on. So shout out to you. They say good evening, fam. Good evening to you as well. Good morning, good afternoon, good evening, and good night. No matter where you guys are in the world, we love having you here. Next in chat shoutouts, we've got Rocket Mob. Wow, thumbs up. Rocket to the moon. After like, man, there's so much fucking good shit going on right now. We've got Donald Trump winning the Electoral College. We've got the Richard Hart hearing went on and it was awesome. We've got people all over the world. There's so much good shit going on right now. I don't know if I have enough room in my heart for all of this emotion and all this fantasticness, but it's gonna be crazy. I'm gonna be jacked and juicy and ready to rock and roll for a long time.
Will, you make it sound like you're the Grinch with a tiny heart whose heart has grown 3 sizes on this day.
That's correct. I am the Grinchful SEC whose heart will grow 3 sizes, and we're gonna turn all the SEC lawyers into hexicans one way or another, bro. They'll be all staking Quattro Cinco, and I don't know what else the SEC does as far as like monetary stuff goes, but they're gonna be on our team. We're gonna be on their team, and it's just gonna be nothing but fantasticness. To finish out shout outs, we've got one more as I can see, Mrs. Producer. We've got Just Live saying word salad is no longer on the menu. You're absolutely right. And I've got one question and one question only for the folks at home, and that is, can you handle the truth? To quote Jack Nicholson, or no, you can't handle the truth. Damn it. All right. Well, I've mixed matched the quote from Jack Nicholson to like, I hope that the SEC can handle the truth, and I know that you guys at home can handle the truth. So it's gonna be awesome. Shout out to Zenith, by the way, for making this awesome this super cool what do you call it, a thumbnail. And then shout out to Mrs. Producer for putting up this fantastic like background and the little judge thing up there and the SEC lawyer box. You whipped it up like in no time at all, because like this transcript literally came out yesterday, and so I was not expecting to do the stream as soon as possible. And shout out to Pulsechain, the Pulsechain Foundation. Yes, because they were the ones that actually financed this, or they were the ones that got a hold of it. I was planning on doing it, but they beat me to the punch because they're much more I guess they're much more ambitious and stuff than I am. Oh, we've got more chat shoutouts. We've got Quattro Cinco 369 saying sweet. What's good, Quattro Cinco? Excelente. Good to see you. And then Mrs. Producer, go ahead and just as the chats come up, we're gonna go ahead and hop into the actual reading itself. So as the chats come up and as people as people show up, make sure that you bring them up as appropriate, and that reign is all over to you. So if you wouldn't mind, Mr. Producer, I have a fantastic screen share. So, ladies and gentlemen, boys and girls, crypto degenerates, ducks and squirrels, we're going to go ahead and start going through this reading. I'm going to be playing the part of the SEC lawyers. Mr. Zenith down there will be playing the part of the Richard Hart lawyers, and SJ will be the judge. So, for the folks at home who don't know, in the district court, in the United States District Court, New Eastern District, there was a case that happened last Thursday, October 31st, which is Halloween, 2 p.m. It was Richard Hart, aka Richard Schuler, Hex, Pulsechain, and PulseX against the Securities and Exchange Commission. This is the case number right here. That's not really terribly important. This just says that this is the transcript and who it's for. We've got Judge Carroll. The plaintiffs, as you guys know, the Securities and Exchange Commission, represented by Matthew Gold and Ben Curvilla, Matthew Gold and Ben Curvilla, I believe his name is pronounced. And then on the defendant side, we've got Michael Liftick, we've got Christian Thaler, we've got David Kirk, and we've got Samuel Nitze. And those are like, I'm going to be reading all the SEC. Zenith is going to be reading the part for each of those people. So I'll go ahead and start off as the courtroom deputy for the folks at home, and then we'll just hop right on into it. Good afternoon. This is an oral argument on the defendant's motion to dismiss the Securities and Exchange Commission versus Schuler, case number 23 Charlie Victor 05749. Will the parties please introduce yourselves for the record, starting with the plaintiff? And that's me. I'm the SEC, so I'm going to go ahead and put on my SEC evil red hat right now. So, good afternoon, Your Honor. I'm Matt Gold for the SEC. Good afternoon, Ben Curvilla for the SEC.
Good afternoon.
Oh, shoot. This is me. Oh, no, this is Zenith.
Nope, that's you.
Oh, no, this is me. Damn it. Kleinman. Yeah, look at that. Good afternoon, Your Honor. Derek Kleinman for the SEC. Good afternoon, Your Honor. Judge Tenorio for Jorge Tenorio for the SEC.
Good afternoon.
Good afternoon, Your Honor. Michael Liftick from Emmanuel Urquhart and Sullivan for defendant Richard Hart. I'll start and introduce the folks we have over here. I have my partner, Kristen Thaler and Sam Nitze. We also have Clark Smith and Viazor. We have Patrick Smith and Brian Burns. From Kirk and Ingram, we have David Kirk and Michael Ingram. And from Gray Reed Firm, we have Chris Davis.
All right. Good afternoon, everyone. Who is going to be arguing for the defendant?
Your Honor, I will be arguing as to most of the arguments, and Mr. Kirk will be handling the personal jurisdiction argument.
Okay. And for the SEC?
Your Honor, it will be Ben Curvilla and myself, Matt Gold.
Are you splitting up arguments?
Yes, we are, Your Honor. I'm going to be handling personal jurisdiction and questions relating to the Morrison issues, and also the investment contract piece as well.
Okay, you can stand up when you're ready to talk. Everyone can be seated. Counsel, I guess we'll take your arguments from the table. I'll have you remain seated because of the way the microphones are set up. I think, first of all, why don't we begin with Mr. Kirk and the issue of personal jurisdiction?
Thank you, Your Honor. Can you hear the microphone okay?
I sure can, yes.
Your Honor, as for the SEC's complaint alleging that Mr. Hart, a resident of Finland, published blockchain software programs, put information about them up on websites and online videos, the complaint alleges that some persons in the United States executed that software or viewed that online content. That's not nearly enough to establish personal jurisdiction over Mr. Hart or casually show that he engaged in any domestic transactions that should be subjected to U.S. securities laws. If I could, Your Honor.
Is that simply because you're saying it was a global, the terms of the information on his website, it was globally to everyone and wasn't directed to the United States?
That's correct, Your Honor. I think in contrast to some of the cases that parties have cited, including your opinion in PlexCore, Mr. Hart's, both the blockchain software programs he developed and the websites and information he put up about the software in online videos is available to the world at large. And under the Second Circuit's opinion in Best Van Lines, as well as a number of more recent authorities in district courts, as well as more recent internet authorities in other circuits, courts have started to realize that the World Wide Web is inherently worldwide. And just because persons in one jurisdiction are able to go and access information doesn't mean that the person who put that information online, or in this case, the blockchain software programs were online, has expressly aimed any activities at the forum. That's the test under Calder, is that the defendant has to expressly aim his activities at the United States. We don't think the SEC makes that showing.
What about the conferences that the SEC makes reference to? It's your position there that thereafter the offer period and therefore, let me try that again, hold on. What about the conferences that the SEC makes reference to? It's your position there that they're after the offer period and therefore not relevant?
That's right, Your Honor. And we've actually prepared a demonstrative just to help set out the timeline, because I think two things that I'd like to bring to your attention. The first is that there are 3 different software programs at issue here, and the SEC calls those software programs. They call them security offerings. Obviously, we disagree with that. And if we disagree, if we discuss offerings here, we're not agreeing with that contention. But what I think we can all agree on is that the software programs, they started and ended on different dates. They involved different alleged facts, different software codes, different statements, different assets, different people. If the SEC doesn't meet its burden to show jurisdiction and domestic transactions as to any one of them, then that one is out of the case. So that's why, with Your Honor's permission, I hope you can see the demonstrative okay. We also have copies.
Have you given them to your adversary?
We have before the hearing, Your Honor.
Your Honor, if we can get a few more copies, we have just the one.
Let me clarify one thing, which will shorten the arguments. Addressing the SEC, you have abandoned, I take it, any alter ego theory that you had set forth in the original complaint? That's gone?
Your Honor, it's not part of this motion. It's not relevant to this motion.
Have you abandoned those claims or not? Counsel raised the issue that they weren't viable claims, that the Pulsechain, the blockchains themselves, weren't entities. Are you pursuing that or not pursuing that?
I think with respect to alter ego, Your Honor, we allege that because we had some facts to suggest that Mr. Hart has control over these entities, that he's controlling the websites, etc.
But you've named the blockchains themselves as defendants. What's the basis for doing that? And are you continuing to do that or maintain that they're defendants?
Right, Your Honor. Again, it's not relevant for this motion, but we are... The reason we did this in the first place was because, again, to the extent there's an argument that Mr. Hart is not responsible for any of the conduct that's alleged in the complaint, that there are all within the responsibility of Hex, Pulsechain, and PulseX because they exist on the blockchain. He has no control over them. They're their own thing. We wanted to ensure when we pled this that we are covering the entire scheme, that we're covering all possible defendants. So that's why...
I'm sorry. Why isn't it relevant to the motions? It was part of their motion to dismiss, I think.
Right. And we haven't responded to that argument, Your Honor.
So you're agreeing that they should be dismissed then?
It's not part of our right. It's not part of our theory for why the court would have personal jurisdiction.
All right.
Your Honor, if you have questions on that, I'm happy to speak about it, but I did just want to make clear that it is our position we move to have them dismissed, as I think counsel has acknowledged even if they didn't respond to those arguments. I do just want to point out that we cited case law in which opposing counsel has cited, they named non-existent entities as defendants. Again, our point was you can't do that. I had cited the case. Sued as a defendant is a division of the New York Police Department that didn't exist. It wasn't an entity. And the court on a motion by the city of New York said, okay, we're going to dismiss that because you can't bring a suit against a non-existent entity. Same with the lawsuit that named a television series as a defendant. We think this is the same kind of problem. I'm happy to elaborate on that, Your Honor.
No, I don't think that's necessary. You have this chart here. I take it it's your position that for both Hex and Pulsechain and PulseX, that the contacts that the SEC relies on heavily all occurred after the offering period for those three entities or securities, correct?
That's correct, Your Honor.
And your chart presumably shows that.
That's right. That's our position. I think that it's important here to unpack each of the three software programs because each one is different, and they occurred. The events that the SEC has brought this lawsuit about occurred at different times. If we take Hex as an example, Hex is a software program that Mr. Hart launched on December 3rd, 2019, and there was a period about 11 months called the Adoption Amplifier period, and this is what they're suing over. This is the period of time when users could execute the Hex software and use it to generate Hex tokens. The first of these conferences that they allege shows the ties to the United States wasn't until March of 2022. That's well over a year later. And so we don't think it can have any conceivable connection to what they're calling the Hex offering. Again, we don't think it's an offering, but we don't think it has any conceivable connection to this adoption amplifier period that ended more than a year before this first conference. I think that's an easy sort of open and shut case when it comes to Hex. I'd like to also briefly touch upon each of the Pulsechain sacrifice and the PulseX sacrifice again. Two different transactions according to two different time periods. Pulsechain, as you can see from the slide, July 15, 2021 through August 3rd, 2021. Again, many months before the first of these conferences. And PulseX was December 29th, 2021 through February 26th, 2022. Again, it ended before the first conference in March of 2022. Now, the only thing, as far as we can tell, that sort of they're using it as a basis to, I guess, claim that this conference has some relevant is they have one allegation that says both the Pulsechain offering period and the PulseX offering period were unofficially extended, are the words used, until April 6th of 2022. We're not sure what unofficially extended means, and it looks like they got that from the declarations of Kyle Barr. He's an individual who, that's what he said, and I think that's all we have to go on for that one. And just a couple of things that...
Well, isn't there evidence, though, that there were transactions after April 6th, 2022? In other words, people were able to go in and put money in and get whatever they got?
Your Honor, one of the strange idiosyncrasies about blockchain transactions is both the PulseX sacrifice wallet, to use the SEC's words, and the Pulsechain sacrifice wallet. Both of those wallets are essentially blockchain addresses that anyone can send assets to who uses the Ethereum network. I could do it today, and that can never be stopped or turned off. It's sort of like a P.O. box, or even more, it's kind of like the night drop box at the court. Anyone can walk up and put a digital asset into it. They can do it today. So I think it's correct that as a technical matter, people can still send assets to this address. I don't know what that would accomplish. I think nothing, but that's just sort of the technological nature of how the blockchain works. However, in terms of what was actually happening after the close of these sacrifice periods, this unofficially extended period that lasts until April 6th of 2022, well, if you look at the Pulsechain website, and we have this using the internet Wayback Machine in a footnote in our reply brief, the Pulsechain website actually said, as of early August 2021, the Pulsechain sacrifice is over. Don't send any more money. And so we're not really sure where they get this offering, to use those words, this sacrifice.
But you're making this argument to say, I take it, that I shouldn't consider anything said at the Hex conference about Pulsechain. Is that the reason that you're making this argument?
That's correct, Your Honor. I think that's why, to us, the unofficial extension makes it, we don't think that's an allegation that is specific enough to be credited. With that said, Your Honor, suppose we say, for argument's sake, if we do credit let's see what happens if the time period for the sacrifices lasted up until April 6th, 2022. Let's think about what the consequence of that would be. And so the only thing that gets into that extended timeline is this March 2022 Hex conference. And just to drill down a little bit on what this is, that's a community-run Hex conference in Las Vegas. Mr. Hart was invited by video to attend and receive a Lifetime Achievement Award from the community and give some remarks by video. So he speaks for about 2.5 hours. That's all in the declaration. He talks about a lot of different topics. During the talk, he mentions that the Pulsechain and PulseX software seem to have product markets because thousands of people join the chat rooms about them. And that's it.
So you're saying that it's not related to the claim, in essence?
That's correct. For Hex, again, we could put that one to the side because the Hex offering ended more than a year before. Again, using offering just to use the SEC's terminology. But that adoption amplifier period that allowed users to generate Hex tokens on software, that was long over. What I'm saying is that for Pulsechain and PulseX, they're saying the offering period was extended and this video appearance gets Mr. Hart with a United States connection, and it's based on 2.5 hours of remarks during which he mentions offhand that there are lots of people in chat rooms about Pulsechain and PulseX software. We don't think that remotely supports the assertion that these were promoting the sacrifices. He never even mentions the sacrifices. To put a finer point on it, Your Honor, if he was promoting the sacrifices to this audience, wouldn't he have encouraged people to participate or mention the sacrifice, or that people should or even could still participate, despite the fact that the website said it was over for several months? And so we think that basically one line about these other software programs at a conference about Hex, about the different software program, one line about software we don't think remotely gets to, enough to support the allegation that he was promoting the sacrifices, if they were even still going on. I think if that was his intention, he would have said something like, there's 1 month left, I encourage you to participate. He never mentioned the word. He just briefly mentions the software.
What about fraud claims? The fraud claim that was presumably to September 22nd, around that period of time, 2022, with the misappropriation. So the fraud claim goes out. What is your response to the personal jurisdiction issue as it pertains to the fraud claim?
Your Honor, Mr. Liftick will speak in more detail about the fraud chronology. I think the timeline there is also a little bit mixed up. But the issue we have for personal jurisdiction as it pertains to the fraud claim specifically is, sort of like with these events we mentioned, there's no tie to any conduct in the United States. The statements that they're relying on that they say were misleading investors, they said they misled United States investors because he was giving them updates and software development. Those statements weren't targeted towards anyone in the United States. Again, he was just...
Are you talking now about YouTube statements? What about statements made in the Miami interview, the PulseCon, those two?
Your Honor, I don't think the SEC has contended that there are specific statements that they think were misleading.
In those conferences?
That's my understanding of their allegations.
So you're just saying that the statements that were made not directed to the United States, but part of this sort of global statements going to everyone?
That's correct, Your Honor. Our understanding of the fraud theory, and again, Mr. Liftick will dive into some of the issues with the allegations themselves, but to the extent they've stated a claim for fraud, and we don't think they have, putting that to the side, they haven't stated a claim for domestic securities fraud because none of this conduct was targeted to the United States. I believe we cited the Aegean Marine case showing that you actually have to have some nexus to the United States conduct to state a fraud claim under securities laws, to state a domestic claim, that is.
Did you have anything else you wanted to add with regard to the personal jurisdiction argument? Because I'll try to take them argument by argument and hear from the SEC on that issue.
If I could just very briefly touch on an issue that I think is important. It's important as the jurisprudence develops, but it comes back to the first thing that you mentioned of there's a difference between information that's generally available and things that are targeting the United States. I actually think Your Honor's decision in PlexCore really honed in on the different factors and the difference between what type of conduct falls on the side of expressly targeting United States persons, or the United States as a forum, and what type of conduct is generally available to the world at large. And I just want to flag that because they were probably interested to see that both we and the SEC relied on the PlexCore case. But that case involved Facebook accounts that marketed and advertised directly to the United States persons, website user registrations, including credit cards and billing addresses, including some U.S. customers, U.S. payment accounts, and payment processors, and even a business trip. Your Honor at least found that there was an issue of fact as to whether it was a business trip to do business relating to that offering at the beginning of that offering period in that case. Again, there's nothing here that resembles that, in our opinion, Your Honor. And we think that the facts here are much closer to what the Southern District considered in Holsworth versus B Protocol, as well as a number of other cases that we cite that just show the way the internet works is you can put content online for the world to see and for the world to access, and that's not enough to show purposeful availment and expressly aiming activities.
Thank you. Who's going to take up this argument or this issue?
I am, Your Honor.
How have you shown personal jurisdiction?
Your Honor, we believe that we've shown it through a mix of different contacts over the internet activity, as already discussed, which I'll elaborate on more, as well as the specific contacts with the United States. Let
me just ask for a concession. First of all, do you agree that you have to establish personal jurisdiction with respect to each of the claims?
So we do have to establish it with respect to each claim, Your Honor. That's a general point I wanted to make. I know the defense wants you to sort of slice it up between each of these offerings, and certainly we did plead them in the complaint separately, because we do take the position that each one of them was offered and sold as a security, and each one of them has to meet the Howey element. So each one of them is a security.
Each one of them you have to establish personal jurisdiction for.
As far as personal jurisdiction is concerned, Your Honor, the point here is that each one of these offerings, although they were separate, they are interrelated. And the way we pled them is that they're interrelated as well. For example, we pled in the complaint that he's telling his audience via his internet marketing and his promotional campaign that Hex is the development of Pulse, and PulseX is going to drive value to Hex. The purpose, one of the purposes of developing the Pulsechain is so that Hex users can now trade on Pulsechain, and it would be cheaper than what it was before on Ethereum. And that once Pulsechain is developed and Hex users begin using Pulsechain, that the value of Hex would go up. So I think it's important.
I think you need to differentiate, though, if you would, between statements that were made just broadly across the globe, which counsel has pointed out are not that relevant or relevant for the question of personal jurisdiction because they're not directed, and statements that you have then pointed out to the court. Well, there were instances where, they came to the United States. He was zoomed into 3,000 people in Las Vegas, the Hex conference, the Miami interview, the PulseCon, virtual appearances in Las Vegas. The question I have with all of those is they all occurred after the offering period. So how are those relevant to the inquiry?
So, Your Honor, with respect to that point, just because the offering period ends doesn't mean that the conduct has ended.
That may be true, but the conduct has to be the conduct we're talking about. It has to be directed. It has to be during the period of the offering.
Well, Your Honor, before and during the offering period, the way these offerings were marketed to the public was that Mr. Hart was going to engage in efforts that included efforts Pulse launched. With respect to Hex, for example, he was going to stay involved. He was going to get Hex listed on platforms, that he was going to engage in efforts Pulse launched to make sure that Hex remained successful.
That may be relevant to your fraud claim. How is it relevant to the other claims? Because the offering sale of securities, that's what your claims are with regarding to Hex, Pulsechain, PulseX. Once that offering period has ended, the terms of personal jurisdiction, why are you considering things that happened after that period? The offering is closed. And what authority do you have that supports the fact that I can consider on the issue of personal jurisdiction post-offering contacts?
Your Honor, it's relevant to Howey post-sale efforts.
I'm not talking about Howey. I'm talking about personal jurisdiction.
Personal jurisdiction is considered what our claims are. Personal jurisdiction goes to what our specific claims are. We have a claim for under Section 5 of the Securities Act, under Section 17 of the Securities Act for fraud, and under Section 10 Bravo for fraud as well. So the Howey analysis is relevant to our claim. So post-sale efforts go to whether or not
there's a security.
Whether or not there's a security, exactly.
But that's not what we're talking about now. We're not talking about the Howey issue or whether or not there's a security. We're talking about personal jurisdiction. For instance, in the Sarkazian case, Southern District, the court determined that contacts that occurred after the events giving rise to the liability, which is here the offer and sale, were not relevant to the question of personal jurisdiction.
Right. Your Honor, so let me address one point. The April 6, 2022, the point that counsel was making about the unofficial extension of Pulsechain and PulseX, our position is that we have pled that as the date, the offerings ended for both of those, for Pulsechain and PulseX. April 6, 2022, the relevant date. We pled it in the complaint. It is in the affidavit that we submitted by Mr. Barr, and we've indicated that the reason it was extended was that Mr. Hart can continue to receive investments through April 6th. So that is a well-pled allegation at this stage, Your Honor. The court has to draw inferences in favor of the plaintiff and accept that April 6, 2022 date as the date the offering period ended for both of those offerings.
For Hex?
No, for Pulsechain, both Pulsechain and PulseX. We pled in the complaint that the offerings periods for both of those were open through April 6, 2022.
Okay.
To the extent that the defense is proffering facts to contradict that, those are not facts that the court should accept on a motion to dismiss. So for that reason, the March 2022 conference occurred during the offering period for Pulsechain and PulseX.
What happened at the March 22nd conference that is relevant to Pulsechain or PulseX?
The entire conference, Your Honor, is a promotion. It's called a Hex conference. It's a promotion for investment. It's an investment promotion.
It doesn't say anything about Pulsechain or PulseX, other than there are a lot of people in a chat room, right?
He talks about that in reference to investment, Your Honor. He says that the fact that this is a product, that it has product market fit. The public is demanding this product. This is how you drive investments. He's talking about holding on. He's talking about advice with respect to Hex holders and Pulsechain and PulseX holders, that they should hold on to their investment and watch it grow. He's providing investment strategy during this Hex conference with respect to Hex, with respect to Pulsechain.
With respect, at least, to Hex, you have to see that the offering period is over for Hex. On the issue of personal jurisdiction, it has no relevance.
I think, well, I understand your point, Your Honor. I think our position, again, with respect to, and I think this conference elaborates this point, he's talking about Hex, Pulsechain together here. In the later context that we have in our motion, the August 2022 appearance in the United States, the PulseCon appearance in September, he's talking about Hex, Pulsechain, PulseX. He's talking about all these things together. I think when the court considers personal jurisdiction, it should consider that point.
Consider it for what purpose? Consider it as it relates to Pulse? As it relates to Hex?
As it relates to Hex. Hex, for example, the offering period.
The offering period is over by the time he's having those conferences. I don't understand how you say that I can consider that.
I think this goes back to the argument, Your Honor, that we have to establish for our claims. We make our claims. We get our Section 5 claim and our fraud claim based on whether or not the offerings are securities, and our evidence for why they are securities include post-launch effort as well. That is relevant to establishing our claims under the Securities Act, under the Exchange Act. And for that reason, when the court is considering jurisdiction, it should consider these facts that are relevant to our making our claims. So let me make another point, Your Honor. On Section 5 specifically, we plead account for Section 5. The factual allegations that support the Section 5 claim are with respect to all three offerings. So at this stage, for our Section 5 claim to survive, it is our view that if the court finds personal jurisdiction with respect to any one of those offerings that support our Section 5 claim, that the Section 5 claim should survive. But it's our view that, again, because these claims, our claims, are dependent on whether or not we can establish that each of these offerings are in fact securities, and in order to do that, the court can consider post-launch efforts, and that's established in the Telegram case, for example, in the Southern District. That is a principle that comes out of that case, that post-launch efforts of the seller should be considered in securities analysis, and for that...
But it's not a personal jurisdiction case.
That's not a personal jurisdiction case, Your Honor.
What are you relying on for the fraud case in terms of establishing personal jurisdiction?
For the fraud case, The fraud case is the offering that is Pulsechain. So it would all be the facts that we've alleged with respect to Pulsechain. So that would conclude his appearance his appearance at the conference virtually before the conference in Las Vegas, his appearance in August 2022 in a live studio for the podcast, and then his September 2022 appearance at the PulseCon. In addition to that, of course, we're using the internet.
Do you use what happened at those conferences as part of your fraud claim, or are you relying on the statements that were made during the YouTube videos as part of your fraud claim?
No, I don't think we're using any of the conferences for support.
They're not part of your fraud claim, the conferences?
That's right.
So then what are your contacts then? Or what are the activities that are directed towards the forum?
Let me also say this.
For the fraud claim.
With respect to the internet contracts, we haven't discussed those yet. As we pled in the complaint, Mr. Hart made comments when he was promoting these offerings, specifically talking about the Howey test, or at least tracking the language of the Howey test. And so he, for example, I think the defense highlights some of this in their opposition, where they quote a line from him where he specifically says, "You are not to expect profit from the effort of others." This is specifically tracking the Howey language. The reason he does this is because he understands that there's a market in the United States, and he's directing those statements at those investors specifically. He understands that there's a market for those securities in the United States. And with respect to Pulsechain and PulseX, Hex has already been on the market at this point. Hex has already been on the market.
Does this relate to your fraud? What does this relate to?
This relates to why statements that Mr. Hart has made in his promotional campaign through the internet, why these support personal jurisdiction. That includes statements that he's...
But you make this argument in your brief that because he talked about the Howey test, he must be directing these to people in the United States. Is that an argument you made in your brief?
That was not made in the brief, Your Honor. But those are facts that are pled in our... Those are facts that are pled in our complaint, and they do again underscore the fact that Mr. Hart understood that there was a securities market in the United States for his offerings. He certainly didn't restrict access.
He doesn't have to restrict access. Where do you get that principle from? That somehow personal jurisdiction is established unless he restricts access?
Well, Your Honor, can consider the totality of the circumstances here, the totality of the context. I would say that if Mr. Hart understands that there is a market in the United States for his offerings, and then he is directing the statements into the United States now globally through YouTube and other social media, he would understand that indirectly this is reaching the U.S. market.
Well, it reaches any market in the world.
Right. So for example, in the PlexCourse case, Your Honor, there were efforts that were made, purported efforts that were made to exclude the United States investors, to exclude the United States investment. I'm sorry, to prevent United States users from accessing Facebook or whatever other social media account was being distributed globally. I understand that those efforts were ultimately unsuccessful. The court found that they were unsuccessful, but it underscores the point that, and I think the court makes this in PlexCore, that specifically because something is available globally, simply because a marketing campaign is targeted globally, does not mean that it does not indirectly reach and have relevance if it indirectly reaches the United States, especially where we have a seller who understands that there's a market for these securities in the United States.
This case is vastly different from PlexCore in terms of the amount of contacts, though. There was a trip to the United States during the offer period. US-based payment service providers received funds. I mean, as counsel pointed out, all of the differences in PlexCore. So are you making the argument here that this case is similar to PlexCore?
No, Your Honor. We don't have all those contacts that existed in PlexCore. With regard to the internet contacts, I would say that the court articulated this principle in PlexCore.
Are you relying on the affidavit you put in for Mr. Bear?
Yes, we are. We understand that that's not one of our principal contacts we're relying on, but he certainly was a developer in the United States who worked on Hex and who worked on Pulsechain and PulseX. We understand that we don't have anything in that affidavit that suggests that Mr. Hart knew that he was dealing with somebody in the United States when he was engaging him for work on Hex and Pulsechain.
In essence, you're not relying on that affidavit.
Right. The other point that I want to make, Your Honor, is the conferences he had, the Hex conference, the conference in Las Vegas in September of 2022. The fact that he's having these conferences also reflect the fact that he understands that there's a U.S. market for his securities. Why else would he be appearing before these markets? Why would he be appearing before these audiences and talking about Hex, Pulsechain, and PulseX if he did not understand that there was a market for his securities there? I think that just the fact that he's having these conferences, and in the case of Pulsechain and PulseX, right around the time of the end of the offering period. Why else would he be having it if he didn't understand fully that there was a market to which these securities are going to be?
Well, the test isn't whether he understood there was a market. Obviously, if he's going to everyone in the globe, he understands that there's likely a market. I think the question is whether he was directing his activities to that specific market as opposed to any market in the entire world. I think that's the inquiry, isn't it?
He's reaching out to these when he's appearing virtually.
But these are, again, we're going over old ground here. The Hex Miami and PulseCon conferences with respect to Hex were clearly after the offerings closed and after the offerings for Pulse and PulseX closed. In any event, why don't we take up a different issue? Thank you. I'll leave it to counsel for Mr. Hart to address the next issue that they think is most important to raise in terms of their motion to dismiss.
Thank you, Your Honor. I think we'll turn briefly to the fraud argument next, but before I do, I would like to raise two broader contextual points that I think have become live issues as part of the discussion, and they're being highlighted and run as a theme throughout the remainder of the discussion, and that is that there's a paradox in how the SEC treats Mr. Hart's statements. The SEC is asking the court to focus on Mr. Hart's statements as evidence for jurisdiction, domestic securities transactions, or fraud. Then the SEC also wants this court to ignore as, quote, tongue-in-cheek statements by Mr. Hart that undermine their allegations. The SEC can't have it both ways. Either the relevant statements matter, and the court can take judicial notice of a significant amount of them, or none of them do. And if they matter, then even taking all the SEC allegations as true, the complaint fails to allege, as we argue, and if you're limiting, if none of them matter and we limit ourselves to Mr. Hart's conduct, what did he do? What is he alleged to have done in the complaint? Then the complaint still fails. The second sort of broad contextual point that will run as a theme throughout the remainder of the argument is that there is a significant issue throughout the complaint. That is, the chronology is out of sequence, leaving the impression that the events happened before or long after or simultaneously when they just didn't. And that Mr. Hart knew of the events before they happened or withheld information he could not have known at the time. We believe the court that the SEC has jumbled this timeline for good reason. Once you actually deconstruct the timeline, the actual chronology would make apparent that the technology at issue is very different from the crypto projects that they mention in a lot of their briefing. This project is more like Bitcoin, fully built when launched, and that impacts legally how the complaint continues to fail. I'd like to turn with that context to the fraud claim. As counsel for the SEC has admitted, the fraud claim is quite narrow. The fraud claim only relates to the Pulsechain project. It also takes up an incredibly small amount of the SEC's complaint. It's only 6 paragraphs, 2.5 pages of their entire complaint. It is very thinly alleged, and it is very narrow. To be very clear, and I think Mr. Curavia conceded this point, the context in the affidavits that were submitted as part of the jurisdiction discovery are not in the complaint. They have not alleged that the Miami conference or any other later event as giving rise to the fraud claim. It's quite narrow. The second important point is that the SEC concedes that this is a claim that is based only on scheme liability. They have not alleged a false statement or omissions case. Under 10 Bravo 5 Bravo, they have conceded that this is a 10 Bravo 5 Alpha or Charlie case. Or under the Securities Act, it's the 17 Alpha 1 or 3 case, not a 17 Alpha 2 case. So, to establish scheme liability in broad strokes, the SEC needs to establish the omission that they allege and deceptive conduct. Obviously, they've done neither. It's a Second Circuit law that misstatements and omissions alone cannot establish scheme liability. That's recent Rio Tinto case that the SEC brought. And here, this is the point where about statements come into play. Mr. Hart's stark disclosures make any fraud claim impossible. Mr. Hart clearly disclosed in plain English and unambiguous language that people who send assets to the sacrifice address lost those assets.
Why would they send them? What is the earthly purpose of sending money to lose money?
Your Honor, the complaint doesn't give us anything on that. Frankly, I would be speculating if I were to guess why people were doing it. But what Mr. Hart said, again, we can return to his words, is that he asked, what is this sacrifice? This is my declaration, Exhibit C at page 11. When you say sacrifice, what does it mean? What is a sacrifice? Mr. Hart says, you lose your coins. You don't have them anymore. For the political statement that you believe free speech is a protected human right and blockchains are speech.
What does that mean?
Well, we can't really go beyond his words in the context of a motion to dismiss, but I think he's getting at is to express one's political belief. Here is something you can do, and as a community, people are going to be aware of that statement and acknowledge that statement. One imperfect analogy is flag burning. You can destroy something to make a political statement. Here, people are choosing to sacrifice assets.
To build a blockchain, right?
No, Your Honor. That's expressly not what he said. This is sort of a key. We really have to look at what Mr. Hart said. He said the sacrifice is the coins are gone. In another place, he says, you should have no expectation of profit from the work of others. You have lost your money. You have sacrificed it. It is gone. The SEC themselves, I don't think, can draft a more explicit, stark disclosure.
Why is he later in October 8th, for instance, of 2022, talking about things like you're not getting any updates on Pulsechain, PulseX, they're done when they're done, the developers are working on it. Why is he saying that if someone has just given their money over for nothing? Why is he making those comments? Why is he talking about that? Why is he talking about that at that point in time?
Again, the complaint offers us no clue about that, and it's not part of their fraud claim. I think we have to remember that there are essentially two events that happen. There's the sacrifice event, and Mr. Hart undertook to build blockchain. And so he's speaking about the updates on Pulsechain blockchain and the progress they're making there.
What happens to all the money? I mean, in terms of how you view what the complaint is saying, people are investing all of this money, and what is this money supposed to be used for?
Well,
according to what Mr. Hart is saying.
Right, again.
It doesn't make any sense.
Certainly, it may not be a choice that Your Honor and I might make, but it is a choice that people are free to make, and he's very clear with them. What Mr. Hart did not do is he did not give them a use of proceeds. Mr. Hart did not say, if you sacrifice to this address, the money will be spent to build the Pulsechain blockchain, and we're going to spend X amount on coders and X amount on...
Well, even if he had said that, aren't the facts, as at least established in the complaint, even if he had said, give me the money, I'll build a straight blockchain, you'll get all these tokens, everybody will be happy, that all happened, correct?
Correct.
And there was never any statement that he wasn't going to take a fee or a cut from this or anything. Even if you viewed the statement as, yes, I'm going to develop this, you give me the money, you fight. It's wonderful for free speech. Blockchains are free speech, and you might get airdrop tokens, which is at the end of that speech. I might add, even if you viewed that as what he said, he did all of that, correct?
We agree completely, Your Honor. There was no statements made that he would not spend money or a very small portion, and the SEC is grasping to turn statements that they don't like into an omissions case.
Sorry, my screen's refreshing. Let me see if I can get it up on my phone too.
You're good. And he's back.
I'm back. All right, where were we at?
Page 36, line 16.
Okay, line 16, right here. Can you guys see it?
I can't.
Oh, shoot, I'm not screen sharing. Hang on. Apologies, ladies and gentlemen. We have
breaking the
technical
action.
difficulties. How's that?
Oh, yeah. Okay.
Back. We agree completely, Your Honor. There was no statement made that he would not spend the money, or a very small portion, and the SEC is grasping to turn statements that they don't like into an omissions case.
Your position is a little bit puzzling because you seem to put all your eggs in one basket, which is there's no fraud because he told them they were giving up their money. That seems to me a little counterintuitive that people would just send money on that understanding.
If I may, Your Honor, I think there's two elements to our argument. The first is, where is the omission? I think Your Honor aptly walked through where is the omission, and our point is the SEC's argument seems to be that can't possibly be what happened. In fact, they must have known. it must have been said that the money was being used. So we're just simply drawing out what was actually said. What were the words? What were the disclosures that were made? The second point relates to their attempt to create allegations of deception. And their allegations of deception have to do with back and forth transactions.
Tell me about those. The mixer transactions that seemed a little odd. Tell me why that's not suspect.
For a very simple reason, Your Honor. In order for an act to be deceptive, you have to be tricking somebody.
You have to be what?
Tricking somebody. You have to be hiding something from somebody. The SEC alleges that mixers are used to anonymize transactions. Well, these are all blockchain transactions, so anyone can see assets being transferred into that mixer. If everyone knows that mixers are used to anonymize transactions, then what you see on the blockchain is assets going into a mixer, and it is apparent that it's being used to anonymize for whatever reason. But there's nothing inherently deceptive about using a mixer. So with back and forth transactions, these are all visible on the blockchain. It's almost impossible to deceive people about blockchain transactions when you can see them in the blockchain when you look at the code. That's very different than the cases that the SEC relies on, like Sugarman, where they're setting up shell entities to hide who owns an entity. Sugarman is a very interesting because what they do there is an Irish company with an Irish name based in Ireland that they're going to be selling assets into. And it's alleged that what they do is set up a Nevada corporation with the exact same name, and they trick the investors to send the money to the Nevada corporation instead of into the Irish corporation. There's nothing akin to that here. It's very plain on its face what's happening with the assets. Mr. Hart was very clear that nobody should expect anything. They're sacrificing as a free speech statement, and then these things happen to be assets. That's a small portion of the assets were sent to the
assets that they allege, the SEC alleges, though, that as a result of all these mixer transactions, they ended up in a wallet that was Mr. Hart's private wallet. Have I got that right?
They don't actually allege who owns the private wallet, I believe, but they do eventually allege the transactions in various goods, watches, and cars. Again, here's where the chronology becomes important because the statements...
They do allege that it went into a wallet controlled by Mr. Hart, correct?
They allege in their fraud claim.
That's what I'm talking about.
Correct, Your Honor. They allege that the assets, it was not disclosed that the assets would go onto a private wallet address, and if there were a disclosure obligation to disclose that after the period was over, some amount of the assets would be sent to a private wallet. Again, there is no affirmative duty to disclose on which SEC can pin their allegations. There's an understanding, a plain statement. There is no omission. They didn't touch the topic of how assets would be spent. And so one of their claims is it was not disclosed that assets would immediately be transferred from Pulsechain sacrifice address to the private wallet. There is no disclosure obligation for that. The other important point is the chronology, which is that the alleged mixer transactions and alleged back and forth does not happen until January of 2022, well after the alleged purchase of the goods that they are.
I have to say I was confused. Maybe this question goes to the SEC as opposed to you, but there was some footnote that suggested that there were funds taken out or this mixing happened throughout the course of the... I didn't understand the footnote, quite frankly, but I'm not sure it was your footnote.
Your Honor, I think you're right. The chronology, which you have before you, is the Pulsechain sacrifice period, even unofficially extended, goes to the end of April 6, 2022. The complaint alleges that these various goods were purchased starting in August.
August of when?
August 2021.
When did the period begin?
The period began in July of 2021.
So, I mean, it could be that he took out the initial assets that were being deposited.
It's not in the complaint. I would also point out that the SEC has, in their opposition, raised a new theory. And obviously, you can't demand in your opposition, and so...
What new theory do you see them raising?
The new theory I see is the theory about adding another statement about money going to charity. And we can walk through that, but it's not in their complaint.
That was the statement about where the money wasn't going. There wasn't a statement about where money was going. It was a statement about where money wasn't going, correct?
Well, again, what they've done is they've quoted it out of context. And the question, the specific question, was, so the money that is raised by Pulsechain, essentially, for the most part, goes to charity. And Mr. Hart says, no, they're different. If you go to sends.org and send them an email, some of it went to charity. $26.5 million is done as money in the bank. And then it goes on to say, but it's not the 5 billion that you see on the other sacrifice addresses. Those addresses, to the best of my knowledge, do not go to charity. Right there on the web, it says you have no expectation of profit from the work of others. So to the extent that 26.5 million did go to charity, that's a true statement.
That was 26.5 million of funds of Pulsechain that went to charity. I haven't heard that before. So I'm just...
This is the problem with amending through opposition, Your Honor. It's not laid out. But they do raise this statement, and there is money that was sent to a different address, but that was designated for charity. But...
Well, I guess this is outside the complaint, I take it.
Yes.
Did you have anything you wanted to add, or I can hear from the SEC on the question of fraud?
Reserving to reply, yes, Your Honor.
Counsel, you're going to take this issue?
Yes, Your Honor. Thank you. Your Honor, it's not that the SEC's conceded that we're only seeking a fraud scheme. We're seeking a fraud scheme as set forth in the complaint. We only sued Mr. Hart under Section 17 Alpha 1 and 2 and Rule 10 Bravo Alpha and Charlie. So there's no concession. That's what we set out to do. To support the fraud scheme, we do have an omission. We have kind of deceptive movements.
What is the omission? The omission is what? That I didn't say I was going to spend some of the money on myself?
The Matrix initiatives, which they cite, says disclosure is required under these provisions of the U.S. securities laws, but necessary to make statements made in light of the circumstances under which they're made, not misleading.
What statement did he make that made the failure to disclose that he was going to use his assets misleading? What affirmative statement did he make that using the assets made misleading?
Number one, what he was talking about while he was raising money for the Pulsechain offering, lamenting publicly in response to Pulsechain investors who were frustrated, apparently, about the timeline of the rollout, stuff is hard. He's saying that software development in connection with Pulsechain was hard, that he had a team of developers working on Pulsechain, and that his investors would have to wait. That's one example.
You glean from that he's telling them that I'm using your assets to develop Pulsechain.
I'm saying that that is an example of a statement made, which under circumstances to omit the fact that in January 2022, he had already used millions of their dollars directly. And by the way, Hart sets himself out as a mega millionaire. He's not using his prior Bitcoin money. He's using money that's directly traceable to what's just coming in from Pulsechain investors to buy luxury goods for himself, like cars, watches, and ultimately the biggest black diamond in the world, not to hire more developers, not to pay developers for overtime, not to hasten or at least split among these. And it is misleading in this context to talk about the development and not also mention that he's doing that. He's spending Pulsechain investor funds as soon as it hits his hand. That would have altered the total mix of information available to his investors. And we point to a specific Brooklyn investor that told us he expected Hart to use the Pulsechain funds to actually develop Pulsechain.
Pulsechain was developed, correct? And some investors got tokens. So why didn't he do what he said he was going to do? How is it fraud if you do what you say you're going to do?
Pulsechain was eventually released as evidenced by these conversations that he's having with Pulsechain investors, clearly not released as fast as they wanted it. The comment I just made, I mean, he's giving an exasperated response to the Pulsechain investors saying, we're going as fast as we can. I hired developers. We're working on this. And so while Pulsechain...
Have you alleged those statements are false?
We have alleged in our complaint that these statements, and I believe that the statement is rendered misleading by the omission of the statement, that the omission of disclosure that at the same time he is, in fact, using millions of those dollars, their dollars, directly for personal luxury purchases, Rolex, McLaren, Ferrari, and a black diamond. There's one thing that Mr. Liftick said that I really have to address, Your Honor, and Your Honor was hinting towards it. Hart spent a lot of time arguing that these are not investor funds, and there can't be any expectations about the use of these funds. You know, harking again to Howey, and an example of how Hart is speaking into the United States, by the way, because otherwise it would not have been relevant. And we're talking about this interview.
Which interview are you talking about?
The one they included in Exhibit Charlie, and they cite at page 11. I'd like to focus on pages 11 and 13 also, but it's got language in there.
Is this the Miami interview?
This was a YouTube interview.
Okay.
I don't believe he's in the United States when he gave this. He says those words. He says their sacrifice, lost and gone, with no expectation from the sacrifice. This is worth unpacking, number one, because it's obviously not true. He directly contradicts himself afterwards, and because, also, Hart relies on this idea of loss and gone repeatedly through the briefing.
Do you allege anywhere in your complaint that these were false statements that he made?
Throughout the complaint, the idea that he's alleging that Pulsechain sacrifices were not going to his personal use, that concept.
He doesn't say that anywhere, that I'm not going to take, I don't know what you want to call it, a fee or anything else. He doesn't tell any of the investors that he's getting nothing out of this. This is not like a fraud where you say to the investors, all this money is going to this charity and I'm not taking a bit of it. And then it turns out that the money is taken. And the next thing you know, you're spending 4 months in jail. It's not the case.
It is not that case, Your Honor. You're right. This is a case where the things he's saying are rendered misleading by him also not saying, by the way, you probably want to know that I'm spending your money as soon as it hits my hands on these cards. So the briefing...
Does it make any difference what he spent the money on? The question is, could he take money out? Was he permitted to take money out?
Am I back? I think I'm back.
Yeah, you're back.
Check. All right, cool beans. We're at
line
20, correct? Okay, excellent. It makes a difference if he spent it on the enterprise or not.
I understand that. But if he took out personal money, you keep emphasizing that. If he is entitled to money, and I know you dispute that, and he takes money out, it doesn't really make any difference, the nature of the purchases that he made, as long as he was permitted to take some money out if he took it out as a fee.
In one sense, no, and I don't disagree with that. In another sense, Your Honor could consider it in terms of we're not talking about subsistence goods. He's Gene Valjean over there stealing a piece of bread. I want to speak simply about Exhibit Charlie, where they quote Mr. Hart as, and he's explicitly, very thoroughly, implicitly referring to Howey and saying, you should have no expectation of profit from the work of others. You've lost your money, you've sacrificed it. But then, in the very next breath, he says, lucky you. If you get an airdrop of 10,000 pulse per each dollar of sacrifice that you performed weighted against that rate I was telling you about. And then he goes on to talk more about multipliers and how lucrative Pulsechain might be for these folks. Hart cannot claim that these sacrificed funds are lost and gone in one breath, and then turn right around in the next breath and tell investors that what they're getting for their exchange. It gives up the whole joke here.
Did you mention this added paragraph in your brief? I don't remember.
We pointed to the exhibit in the exchange, I believe, but I don't think we talked about the lucky you paragraph. That idea, when we talked about tongue-in-cheek, and we're a little bit mocked to the idea that you can't rely on him and then also call his statements tongue-in-cheek. I'm certainly responding to that argument by saying we can hold Mr. Hart to his words and we can point out obvious contradictions where they exist. Pulsechain was still being developed at this time, and so Hart is speaking about an investment in the enterprise. Pulsechain hasn't been released yet. By his own words, he was still developing Pulsechain. So Hart is simply not being serious when he says Pulsechain funds are gone. This is another example of him not being honest with investors. So not only did Hart use millions of this Pulsechain investor money for himself, not only did he misleadingly omit this information from investors, also took this money through a series of back and forth transactions.
Those were all public transactions, though. If someone wanted to take the time, I take it, it would have been publicly available. They could have seen what was happening.
I don't think that's true as to where they end up. So I don't think it's as transparent as Hart would have you believe. The results of these 2022 back and forth transactions, and also the use of a crypto asset mixture. One reason is because we don't have full information about who owns the addresses. So even if there's public to the public, you don't know who is transacting. Again, we return to when Mr. Hart is talking about in the briefing why these can't be deceptive acts, these back and forth transactions. He goes back to the idea of lost and gone. You can't have deceptive transactions about money that you had no expectations about to begin with. We've already discussed that lost and gone are effectively a sham, part of Mr. Hart misleading us here. Hart immediately retracts it with a little bit of a wink and a nod saying, lucky you, if you get all of these pulse out of the deal. We have alleged a reasonable investor would expect Hart to use the funds to develop the enterprise, and we've alleged a Brooklyn investor believed that. Now they poke holes on the Brooklyn investor and they point to the National Elevator case that talks about needing to establish a confidential witness's reliability, saying we haven't done that. That case is definitely not this case. The 4 confidential witnesses in that case, they needed a more specialized knowledge to testify about the things that are being quoted on. It was pointed out that they had no routine interaction with the particular corporate project at issue. They had no firsthand knowledge of the facts contradicting the executive of the company's public statements. Here, the only bona fide that matters is that the Brooklyn investor was an investor in Pulsechain, and we have alleged that. So, Your Honor, we have deceptive conduct.
The greatest number that you have alleged is not in the complaint, but I recognize you could amend the complaint to add it. But you have not alleged anything more than 10 U.S. investors. Am I correct about that?
As written in the complaint, yes, Your Honor.
I don't think that's even in the complaint. That's all you have, right?
Maybe we should get a show of hands from the folks in the gallery.
I would just as soon not.
Yes, Your Honor, you're right. We have only alleged that. As I sit here today, of course, I believe many more than 10.
How does that relate when we talk about going? There's an argument that's been made, and perhaps counsel needs to articulate the argument quite apart from the fraud argument and quite apart from the Howey argument about whether these are investment contracts that meet the Howey test. There's more of a preliminary argument about whether these are domestic securities transactions. And let me ask if counsel wants to address that issue, because that seems to be a fairly significant issue.
Your Honor, we can talk about the Morrison issue, but before we go there, I do feel like I need to address a couple of points about that Mr. Gold made. It's a little hard because it almost sounds like the complaint is being amended in real time. We know that they didn't like that the assets are gone, the language, because it doesn't appear anywhere, and in our opinion, it's false. Here's the key. The chronology Mr. Gold spent a bit of time talking about on the October 8th statement. If Your Honor draws attention to the chart that we made, it's literally off the chart. This is in October of 2022, and even under the most expansive version of the SEC's view of our sacrifice period that ends in April 6, 2022. So, again, similar to the argument.
As it pertains to the fraud.
As it pertains to the fraud.
It's not past the fraud, the theory of the fraud case, correct?
I believe it is, Your Honor. If the sacrifice period ended April 6, 2022, how was a statement made 6 months later relevant to decisions that purchasers or sacrificers were making 6 months before? Again, this is why we started with the theme of the chronology. The way they conflate events when things happen is really important here. We want to turn to Morris, we can do that. The other point that is very clear, as Your Honor notes, that ultimately the Pulsechain was built, and there's certainly no allegation about there was insufficient funds to purchase it. There was a significant amount of money that went to sacrifice address, and only a fraction of that is alleged to have been spent on the items that are in the complaint. So we can turn to Morrison. And Mr. Kirk, do you want to address that? Yes, thank you, Your Honor. I'll speak for just a couple of minutes on Morrison and their obligation, the SEC's obligation to plead domestic security transactions.
Because that's the end of the game. If there's no domestic security transactions, that's it, correct?
That's correct, Your Honor. And we think that there's neither personal jurisdiction nor domestic securities transactions. Those are two equally valid ways out. We think that, again, it's not disputed that Morrison applies here, and that it's the SEC's burden to plead adequate.
Well, Morrison, it's disputed whether Morrison applies to the fraud claim, correct?
That is correct.
That it's disputed.
That is disputed. You're absolutely right, Your Honor. So focusing, and I apologize, I'll focus on Section 5 for a moment. On the Section 5 sales claims, we don't think the allegations in the complaint even do the bare minimum. The only thing they say, the only allegation at all, is that some unspecified number of U.S. persons participated in these alleged transactions. That's not enough as a matter of law because in Absolute Activist, the Second Circuit said, and I'm quoting, "The party's residency or citizenship is irrelevant to the location of the given transaction." It also says, "The mere assertion the transactions took place in the United States is insufficient to adequately plead the existence of domestic transactions." That's at page 70 of Absolute Activist. The city of Pontiac, which involved U.S. purchases, made clear that even alleging the U.S. persons placed the transactions from the U.S. is not enough. The SEC here didn't even do that. It just says there are some unspecified number of U.S. persons. I think if those allegations were enough, then we would be back to a citizenship or residency test, which isn't what Morrison calls for. I think there's just not enough meat on the bone. Your Honor, I'm not even sure if there is a bone. The only thing they do try to save that problem is they invoke the recent decision in Williams versus Binance. The problem is none of the facts that animated the court in Williams are present here. In that case, you have transactions with U.S. users that were allegedly matched on the defendant's servers located in the U.S. And in addition, the transactions became irrevocable when they were sent in the U.S. pursuant to express terms of service. Again, nothing like that is present here. The court also relied on what is called interrelated reason.
Do you think that's an independent basis? That's not clear from the decision to me. When it calls it interrelated, can it stand by itself?
Your Honor, my reading of Williams, and obviously everyone will have a slightly different gloss, my reading is that both of these things are what got the court there. The reason is the court clearly said there might be some cases where allegations about servers that were based in the U.S. might not be enough. The court went on, and it went on to describe, I think, the allegations in that case that the Second Circuit found troubling, for lack of a better word, and that is that the defendant entities, according to the Second Circuit, had expressly disclaimed having any location and notoriously disclaimed being subject to any country's regulation. A couple of quotes. They said, Binance expressly claims having any physical location, foreign or otherwise. The court also noted that the government of the defendant's headquarters in Malta had actually disclaimed having any regulatory authority over the defendant.
What would be the equivalent in this case of Malta and Binance?
Your Honor, it's a little bit difficult because we have so few allegations in this complaint. The one thing we have is that Mr. Hart is alleged to be a resident of Finland. Finland has financial services authority. I dare not say the Finnish version of it. I would butcher the pronunciation, but it's alive and well, and it's a regulatory authority. They have other regulatory agencies as well. Of course, it doesn't mean they're going to choose to regulate blockchain technology the same way that the United States must, or that the SEC is at the moment. But, they said they've alleged that Mr. Hart lives in a foreign country. They've alleged that that's where he developed and launched his software. That's where he spoke about it on the internet. And that is where he made what the SEC is characterizing as promises to users. We disagree with that, of course. But all of that is happening from Finland. So, Your Honor, there aren't enough allegations here, and I think we can stop the work there. But as best as I could piece it all together, the only reasonable nexus would be that these activities are happening in Finland, or at least certainly not in the United States. Again, the SEC tries to compare this to Williams, but Mr. Hart is a human being. He certainly doesn't lack a physical location. He certainly hasn't disclaimed having one, and again, no allegation that the Finnish government has disclaimed any responsibility for him. The only comparison that the SEC can really draw between this case and Williams is that they both involve blockchain technology. In the SEC's brief, as I read it, they seem to be suggesting that if transactions occur on a decentralized blockchain ledger, then they have no location under Williams and they should default to the U.S. I don't actually think that's what Williams said at all. I think the court in Williams wasn't concerned so much with the decentralized blockchain ledger as with a decentralized defendant. Again, it was saying the defendant itself disclaims having any location. I think the fact that transactions are recorded on a decentralized ledger isn't really part of the analysis, and if it were, it would mean any time you use blockchain ledger technology as opposed to servers or pen and paper or whatever to record transactions, then you would automatically get to default to the United States. I don't think that's the outcome that Williams intended.
What about this 5 Charlie offer, the analysis there?
So thinking about that, the clear result under the case law that it's the location of the offerer that's relevant. Here, according to the SEC, that's Mr. Hart. I'm not agreeing that he made offers, but it would be the location that Mr. Hart that matters. And that was established and made clear by the court in Ripple. And it was also established many years before by the court in the Goldman Sachs case. We quote both of these. And I'll note that those are both cases brought by the SEC. And in both of those cases, the SEC was very happy with the result that it's the location of the offer that we look at. That was the test, and they were pleased with that result because the offerer in both cases was based in the United States. What troubles me a little bit now is the shoe is on the other foot. There's a person outside of the United States making statements, and they say, oh, well, it should be a different test. Maybe now we should base on where the offers are heard. Again, that's not supported by any case law in this circuit, and in fact, Absolute Activists actually noted that even allegations about heavy marketing in the United States or U.S. persons being affected, again, we don't have marketing in the U.S. Absolute Activist says that sort of thing might satisfy conduct in effect, but not what Morrison calls for, a transactional test. We also think there's no factual basis for this theory because, again, they don't actually provide any particulars of who heard what and where they heard it. The only law that they cite is a recent case from the Western District of Texas called SEC versus Bellina. It's an out-of-circuit case recently adapted for interlocutory appeal, and in addition to not being anything binding on this circuit, it's also a very unusual set of facts that are not present here. The defendant in Bellina was a U.S. resident. He knowingly built up an investment information group with other U.S. participants, along with people from elsewhere in the world. So there's no jurisdiction issue. Here, he's a U.S. resident, and he leaves the U.S. on a 2-month road trip to learn about and promote cryptocurrencies, and in the meantime, he is, according to the opinion, expressly beaming back his information and promotions to his U.S. audience. So he goes away for 2 months, and he comes back to the country when he's done. And the court said it didn't want to encourage people to do what the defendant did by, quote, temporarily leaving the United States to evade United States securities regulations while targeting United States investors and United States financial markets. There's nothing similar at all here.
All right. Thank you. Let me just take up one separate issue, and then I'll hear from the SEC with response to both of those arguments. And this deals with the Howey argument. And I admit to being a bit confused by what position Mr. Hart is advocating on the court with respect to the Howey analysis. You said you're not making an argument that the Pulsechain, Hex, PulseX don't satisfy the Howey test. You're saying that there's some sort of preliminary finding that has to be established prior to. You get to the Howey test about some continuing obligation, and I don't know where that is in the law.
Your Honor has accurately described our argument. The argument is before we march our way through the Howey elements, you have to have a preliminary inquiry. Frankly, at some point in time on a full record after the discovery, we would be happy to argue the Howey elements. But on a motion to dismiss standard, we'd be arguing facts, and that's obviously not appropriate. But the federal securities laws define certain things as securities: stocks, bonds, ventures, note, etc. One of those terms is an investment contract. That language has to have meaning. The investment contract. Now, Howey defines, how do you know once you have an investment contract? That's the box we're in. How do I know if I have a security? Our argument is, essentially, it's not clear to us, and we think under these facts alleged, we're not even in the investment contract box. Now, why is that? You could even use a little bit of Howey to get there. Howey says,
well, most of the cases that you cite of crypto cases, sorry, my eyes just got. Most of the cases that you cite use a lot of Howey to get there, don't they? They're mainly Howey cases examining the third element.
Well, they are, Your Honor. Here's the challenge. Before these crypto cases came about, the stream of crypto cases, nearly every single Howey case actually involved a contract. It's maybe not formally written, but it's an oral representation. But nobody is disputing that there's actually a contract, a binding agreement, some type of agreement between two parties. What is challenging and unique about crypto and about these transactions at issue here, the argument is that there is no contract, there is no agreement, there is no connective tissue between something sitting in their house choosing to execute the hex code, execute against hex smart contracts, get back hex tokens, and anyone else. Howey refers to transaction scheme or contract, and our essential argument is that there's none of those. If there is no transaction scheme or contract, we don't do the Howey analysis. We're not in the investment contract box.
There have been a series of cases that analyze cryptocurrency under the Howey test, and in fact, find that it's met the term investment contract.
I don't disagree. Obviously, there is limited appellate authority here, and we believe that the argument still has merit, even if other courts disagree. But I think one of the other key aspects, if you look at some of the examples, for example, the Telegram case, which counsel mentioned, you look at what happened in Telegram, and there actually was a contract initially. The investors made an investment. Telegram said they were going to develop the TON blockchain, and that at some future period of time, they would release the TON blockchain and the TON tokens. So it was pretty apparent, putting aside again the elements of the Howey test, that there was some kind of agreement and some kind of continuing obligation that Telegram had took on. Our argument here is if you look at the facts as alleged, Mr. Hart made no promises, no undertakings to do anything in the future. Once Hex was launched, fully built, anyone was free to either engage with that smart contract on their computers or not engage with that smart contract. If Mr. Hart, the day after Hex launched, had decided to never go on YouTube again, never do anything related to Hex, and go into a completely different line of business, that would not have violated. There would be no standing for a fraud claim. It was launched fully built. He never said he was going to maintain the code. He never said he was going to make apps available on the smart contract. On Hex, that doesn't work, but on Pulsechain, never said, I'm going to build apps on Pulsechain without any kind of continuing. Individuals who are simply choosing to interact.
Hex was being transacted on a secondary market. And obviously, if it went up on the secondary market, that would be important to investors. Wasn't he at the Hex conference and touting this is after the period ends, but he's touting how great Hex is? Isn't that continuing on to promote Hex, if you will?
Well, I think simply speaking and saying, I think this is a cool program, and let me explain to you how it works, is very different from saying, I have a continuing obligation here to make sure the code works, to continue to refine it, to make it better. It's very different than the vast majority of the crypto cases that the Commission has brought.
Okay, thank you. Does counsel for the SEC wish to respond to the two arguments that were raised? And if there's any short rebuttal, I'll hear it.
First, Your Honor, just to address the points according to Morrison, it is our position that we have alleged, the SEC has alleged, domestic transactions that meets the Morrison test and the test articulated in Absolute Activist. The key inquiry is where there was irrevocable liability incurred. And that brings us both from Absolute Activist and also Williams versus Binance, which counsel referenced is instructive on this point. In this case, we're dealing with a digital transactions that occurred on a digital blockchain. So there's even more reason than there was in Williams versus Binance. In Williams versus Binance, the court articulated the fact that it focused on where orders or where investors sent money from in that case. The reason that that was the focus of the inquiry was because it was dealing with a digital exchange that disclaimed having a location anywhere or disclaimed having a presence in any foreign jurisdiction. Here, we're dealing with a fact pattern that will actually makes that even more significant here, because these were transactions that did not occur on an intermediate exchange of any type, foreign or domestic.
Where did they occur? Have you sufficiently alleged where it took place to suggest that they were irrevocably bound within the United States?
Well, what we've alleged is that investors sent funds to a digital wallet address on the blockchain, and we've...
Where is the blockchain?
It's...
Where does it live?
The blockchain itself is not located in the United States, but our position...
Didn't it not become irrevocable until it hit the blockchain?
Well, no, it becomes irrevocable. It can become irrevocable in a transaction can become irrevocable in multiple places.
What if you allege to tell me where that happened here?
Here, where the investor in the United States became irrevocably bound is when they sent their funds to the wallet address. One thing that underscores that...
How did they do that?
They transferred crypto assets.
They transferred ETH from where to where?
ETH from their wallet address to a wallet address.
Where was their wallet address?
Again, the wallet address exists on a digital blockchain.
Which takes me back to, where is the digital blockchain? How do I know this is all happening in the United States?
Well, we have alleged that investor that's again located in the United States, sending their funds from...
It's not enough that the investor is in the United States, though, correct? That fact alone is not sufficient.
The investor is physically present in the United States with, again, this was Williams versus Binance. The investors were located in the United States, sending funds over a digital.
But they found that there was some matching transactions that occurred within the United States.
Right. We don't have that fact here because, again, we're not dealing with an exchange. Again, Williams versus Binance looked at two different ways where someone could incur irrevocable liability.
Is it your burden to show, at least on the allegations of your complaint, to establish that? Isn't it your burden to show me that and how you do that?
Well, I think we do that using the same analogous facts that are here that are analogous to Williams versus Binance, which is an investor located in the United States sending funds, their funds, from the United States over, again, a digital platform, but they're originating from the United States. At that point, the investor becomes bound to the transaction at the point. And again, Mr. Hart, as I think we've referenced earlier today, referred to, at least with regard to Pulsechain, the sending of these funds as sacrifices. In other words, underscoring the point that once they had been sent, the funds had been committed.
So you take him at his word that they're sacrifices?
No, Your Honor. I think that underscores the point. Just as it would be if someone was making an investment that wasn't called a sacrifice, that once they're paying for something, once they've sent their order, once they've sent the funds, they are committed to the transaction. That's the inquiry under Williams versus Binance. We think we've met it here and that we've pled a domestic transaction. We've pled a Brooklyn investor, of course, in the complaint. We think that satisfied the standard that was set out in Williams versus Binance and Absolute Activist.
Thank you. I don't know if anyone wanted to speak to the Howey issue or not.
Yes, Your Honor. As far as the notion that there is some continuing obligation or that Howey requires some kind of contractually grounded obligation, that argument has been rejected by multiple courts that have considered it. There has been, the test for Howey is clear. It's set forth in the Howey case. Investment money and the common enterprise with an expectation of profit from the efforts of others. And I don't know where they're finding this contractually grounded argument, but if it's in the third Howey prong, which is an expectation of profit from the efforts of others, the test there and the focus there is what expectations were created by the seller.
Not whether they actually came to fruition?
Right. Yes, and not that they were obligated. There is no part in the test that obligates the seller to do those things or requires a contract. It's just what expectations did they create objectively through the way they marketed the asset. In what expectations they create in the investor that they were going to engage in certain efforts that would result in a profit. That's the focus. There's no requirement. Every court that's heard this argument, Terraform, Coinbase, they've all rejected this notion that there is any continuing contractually bound obligation for the promoter to do anything in connection with the Howey test.
Thank you. Anything that you feel the need to respond to that you don't think you've been given the opportunity to address since the burden is with you?
Your Honor, just very briefly on the Morrison point. They said that the test they need to show is where irrevocable liability incurred. Again, there are a lot of factors that the cases look at, like where servers are located, where were orders matched, where was there a meeting of the minds from a contract perspective. And we'd love to dust off our contract case books and get into the details, but there's just none in the complaint at all. It just says United States persons participated. It doesn't actually even say that they did so from the United States. Even if we assume that that were the case, the City of Pontiac, footnote 33, says that even placing purchase orders from the United States isn't enough, that they've never actually said that alone is enough for irrevocable liability. In Williams, again, while Williams did look to where purchasers in the United States were, it was for very specific reasons of both U.S. servers matching U.S. orders, and again, like we said, the express disclaimer of the defendant having a location. Again, there just aren't enough facts here for us to actually do that analysis, and that is the SEC's burden. That's the reason we haven't said more on the topic. There aren't enough facts to have that debate.
Your Honor, if I could address the City of Pontiac point, the Williams court did distinguish that case because it held that in the City of Pontiac, they were dealing with transactions that occurred over a foreign Swiss exchange that was regulated by Switzerland. So there was an exchange that implicated a foreign regulatory regime, which did not exist in Williams versus Binance and does not exist here.
Thank you. Was there anything further?
On that point, Your Honor, again, they're talking about transactions on a Swiss exchange. We don't have enough details, enough allegations to get into the facts, but from what little they've alleged, it, again, looks like there might be conduct in Finland. The question is not, is this a sufficiently regulated market in another country? It's, is there another country that would have jurisdiction here? And without enough allegations to get into it, again, looks to us like they may be Finland, but it's certainly not the United States. I also just wanted to say this sort of comes back to a point we did make in the brief about transactions being predominantly foreign. Again, here the only nexus to the United States is that some unspecified, or maybe it's 10 people in the United States, participated and were involved in different software programs. If everything else is alleged to have been outside the country from the person who spoke about the software and allegedly took responsibility for launching it, everything else is outside the country. I think that's all we have on Morrison, Your Honor.
All right. Thank you, gentlemen. For your argument, I'll reserve decision.
Thank you, Your Honor.
Thank you, Your Honor.
And that, ladies and gentlemen, is the end of the court proceedings. Excellent work, SJ. Excellent work, Zenith. Thank you, Mrs. Producer, as well, for doing an excellent job with all the comments. I hope I didn't cut out too much. I know I lost connection there at least one time. But before we get into our analysis and everything, we're going to do a quick round of chat motherfucking shoutouts because the folks at home have been patiently waiting for the last hour and 20 minutes or something like that. And SJ and Zenith have been reading a whole lot, and I've been reading a very little as the SEC was rather quiet during the proceedings. I hope you guys enjoyed that rendition. And now it's time for some chat motherfucking shoutouts. So, Mrs. Producer, if you don't mind, we're going to start with the Green Observer, who says hello. Shout out to the Green Observer, a good friend of my brother's. Good to see you, amigo. Welcome to the stream. Hope you enjoyed it. Next up, we've got none other than Tam Tam. Hey, fam. What's up, Tam Tam? Good to see you. Welcome to the stream. I hope you enjoyed that. We certainly did over here. Next up, we've got Large. Good morning, degenerates. Good morning to you too, sir. Glad you could make it. Welcome. I love that Stormtrooper helmet with the blood thing, by the way. Excellent choice for a thumbnail. Next up, we've got none other than Red Squirrel. Oi, oi, with the thumbs up. Oi, oi, back to you too, sir. I don't understand, like, oi, oi seems to be a common Hexican greeting. So, oi, oi, oi. Welcome to all the Hexicans.
I think Red Squirrel started that.
Oh, he did? Oh, excellent. Well, good to see you, Red Squirrel. Excellent starting with that. I love it. I know that my good friend Kool-Aid does that, and there's a whole bunch of other Hex OGs that do that. So shout out and good to see you. Next up in the chat shoutouts, we've got Yellowtail. Slept well last night. LOL. I slept fantastic too. I stayed up rather late watching the election and stuff, streamed by none other than Hexologist. Shout out to Dr. Hexologist. Streamed for almost 4 hours covering the U.S. election and all that stuff. I was in the chats having a good time, so I got some good sleepers too. Glad to see you're with us, Mr. Yellowtail. Next up in chat shoutouts, we got Yo Mackie. Hello, everyone. We're going to the moon. 100% explosions all the way around. Good to see it. Welcome, broski. Next up, we got Dammy Johnson saying, I like the intelligence of this judge. Abso-fucking-lutely. This judge was quite keen and on point. I had a feeling going into the courtroom that this judge was going to be like a little bit crypto uninformed or whatever, but that was not the case. She was very wise. It was super awesome. Next in chat shoutouts, we got Pulse Jitsu with Fast Abdul. It was good to have such an impartial judge. 100% broski. And SJ did a very good job of portraying like the tone of the judge and the pace as well. So good job, SJ, on that. It was very accurate. All three of us were there at the proceedings, like sitting front and row right there on the left-hand side. It was awesome. Next up in chat shoutouts, we got Relaxing Sounds of Nature, a wild SJ, as beautiful as ever. Good to see you, Relaxing Sounds of Nature. Thank you. You are absolutely correct. Next up, where are we? Oh, we got Pulse Jitsu with Fast Abdul donating 100,000 money units. Let's talk bribes. I'm glad to hear it, Mr. Fast Abdul.
Mr. Fast Abdul, thank you for throwing 100,000 dongs our way.
Oh, that's what those are. Those are dongs. Wonderful. That's what it's like $5 or $10 or something like that.
It's something like that. It's Vietnamese.
I like it. Good to see you, Fast Abdul. Welcome. And thank you for the super chat. Yes, let us talk bribes for suredly. Next up, we've got Orezzo Evitigan, saying the fires. Good to see you, amigo. Welcome to the chats. I like your icon as well. That reminds me of the kebab remover guy. Next up, we've got Yellowtail again. Judge is a judge for a reason. She has reasoning and duty to balance all points on both sides. I think people that attended made a good impression, and the judge really liked it. Yes, the judge was. She did an excellent job. I believe it was either Zenith or Nuclear Herbs that said in a stream a while ago. The judge did an excellent job of steel manning the arguments on both sides. So, super glad to see her, and that was excellent. Next up, we got none other than Tin Top, our favorite Mandalorian. What's up, Hexicans? What's up to you too, Mr. Tin Top? Good to see you, amigo. Welcome, welcome. Hope you enjoyed it. After that, we got the Herc rolling in. Sup, Degens? What's up, the Herc? Good to see you, buddy. Glad you could make the stream. I don't wherever you are, whether you're in the States or whether you're over there in Africa, it's good to see you, amigo. Welcome to the chats.
Yeah, we
finally
got
Moon.
We finally
What's
did
that?
a stream for Herc at the proper time for him in the evening.
Yes, we did. Yeah, if he's over there in South Africa, this stream would be a good time for him. So hopefully better than the 3 a.m. or 2 a.m. ones that we normally do for you, buddy. But glad to see that you're here. Welcome, welcome. Next up in the chat shoutouts, so we got Moon-Pilled Rational Objects. Fire just got done with the CMC, here to hang out. Shout out to Charlie and Miguel with the crypto mindset course that they put on that teaches people how to get into the cryptocurrency space. That's where I learned the majority of my crypto knowledge, was over there with Charlie and Miguel. So shout out to those two excellent amigos.
Moon Gang, we up.
Yep, Moon Gang, we up. Hell yeah. Next up, we've got Clash of Ideas talking about being bullish. Yeah, from what I understand, we hit new all-time highs while we were streaming, so that's pretty cool. All-time highs for the Grandpa Coin, Bitcoin, all that good stuff. So good job, Bitcoin. You guys are doing well, hobbling around on your cane. I love to see it. After that, we've got XXXXX. Boom. You're fucking A right, broski. Boom goes the dynamite. It was a fantastic hearing and very, very explosive emotions from all the folks afterwards. Once we're done doing the chat shoutouts and talking about our thoughts and everything, I've got some pictures from the event, from like specifically the courthouse and us outside and doing all that stuff. So you get to see all the exciting stuff that was going on. Next up in the chat shoutouts, we've got DJ Pollywood Win. Good to see you, amigo. DJ Pollywood Win rolling in with the pink hand and the fancy sunglasses. Good to see you. Welcome, welcome. Glad you could make it. After that, we've got a Degen Roundtable audience member and fellow streamer aficionado, none other than Paul Sachs. Good to see you. Bitcoin breaking new all-time high again now. Ooh, outstanding. Good to hear it. Good to hear it. I like it when Bitcoin breaks its all-time high because that generally means that wealth flows downward to other people. And also it's good just to see the traditional finance world get a little bit less cool money. So shout out to you, Paul Sachs. Good to see you. Next up, we've got Conspiracy Crypto, my good buddy, Ramon Carrillo. Great job, ladies and gentlemen. Thank you, Ramon. We appreciate it. Shout out to Conspiracy Crypto, my good friend, Ramon. Then next, we've got Human Hex Trafficker. Oh my God, what a name. Rolling in with a thumbs up. Good to see you, amigo. Traffic that hex. Buy it, sell it, stake it, unstake it, send it, wrap it, do all those great things we love. Burn it, Excellent, excellent. Good to see you, Hex Trafficker. Next, we've got RH Max. Hello, gents and lady. Hello to you too, RH Max. Rolling in from the other side of the country. We're covering all parts of the country right now, if I am not mistaken. Good to see you, RH Max. Welcome to the stream. Good to have you. Next up in chat shadows, we've got Henry Vong. Sounds like the judge was prepared and was impartial, asking pointed question for both sides. RH lawyers made a better case. You're absolutely right. Somebody I think it was Hexologist was saying he threw the entire script into ChatGPT and had ChatGPT like summarize it for him, and he was getting some excellent results. So I agree. The SEC made some wonderful points. The SEC not only made wonderful points, but they did a good job communicating with the judge. And I don't know if you guys saw like all the cutoffs that the judge did when talking to not the SEC. The Richard Hart lawyers did a fantastic job. The SEC did not do a very good job. And I don't know if you guys remember seeing in the script, but there's a lot of points where the judge was cutting off the SEC because they were trailing on about things that didn't matter and not answering the judge's questions. So that was super fun to deal with. Next up in chat shoutouts, though, we've got Crypto Ewok. Well done, all. Thank you, sir. We appreciate it. We tried our very best, and it's good to see you. And I'm glad to get. We're always glad to know that we did an effective job presenting a quality product to the audience. Next up, we've got Beyond All saying, wow, awesome, but I hate the SEC attorneys and they suck. I agree. Well, I'm not going to say that I hate them. I will say that they suck and their arguments were not excellent. So it's kind of funny. I think I told you guys a couple times before, but I rode up the elevator to the courtroom with the lead SEC lawyer. Like, I was the only one in the elevator. It was me and him, and some other chick got off on a floor beneath us, but we were riding up to the 10th floor. And I was like, oh, you're going to the 10th floor too? Are you here for the Richard Hart trial? He was like, yeah. I was like, oh, awesome. Good to hear, bro. You're here for his legal counsel, or are you like here for support? And he's like, well, actually, I'm a lawyer for the SEC. And he like kind of like gave me like a sheepish, like shy grin. And I was like, oh, no kidding, bro. And I like shook his hand. I'm like, hey, good job, good luck, and I hope you have a good time, and yada yada. So nothing
I just
but good
hope
vibes.
both sides have fun.
Yeah, I hope they all have fun, and I enjoy. Like, here's the other thing: if we didn't have the SEC, poking and prodding and testing our resolution and testing our stuff, then how would we know that we're the best? It's like the lock that's never tested. How do you know it's going to hold the gate? So I like people that challenge me. I like people that come up and try and break the things that I'm making and that I'm working on. So that way I know that it's legit and it's awesome. And if we didn't have enemies, then we would just get fat and lazy, and it'd be fucking terrible. So thank you to the SEC for doing a good job. And while you guys might be my enemies now, you're going to be my friends later. So I look forward to it. Next up in chat shoutouts, though, we've got Saint Wolf. Sup, Degens? What's up to you too, good sir? Glad to see that you could make it. Good to have you here with us. This is just such a fantastic day. I fucking love it. Next up, we got XXXXX. The judge was more protective of the law than the SEC. They are trying die hard to make a case. Yes, that's absolutely right. And that's what judges do, is they protect the law while the counsels argue it. And the counsels try and twist it. Oftentimes, I should say, not all the time. Oftentimes, lawyers will try and twist perspective to make the law work in their favor of whatever the thing is that they want. And it's the judge's job to be like, nope, this is the objective truth, yada, yada, yada. And we're going with that. Next up, we've got Luna C Point with Bitcoin at $75,600 for Bitcoin price. Good to see it. Thank you, Luna C Point. Glad we could have the shout out and things. Two more chat shout outs, and then I'm going to toss it over to three more chat shout outs, and then I'm going to toss it over to AWildSJ because she's got to bounce. Gizmo saying, where do we see Hex in its next bull run? I see Hex as being an effective tool that I'm going to buy and stake and do things with, and it's going to be awesome. And that's where I see it. I'm not going to make a price prediction that's serious, but I will say that everything at one point passes logarithmic derivatives of 69,420. So at some point you'll see something in that zone. So we've already passed it for Bitcoin, and Hex used to be like 0.6 cents, 0.69 cents. So we're getting through it. Next up, we've got Crypto Compassion saying, I see legends on stream. Thank you, sir. That means a lot. Excellent.
See legends
excellent.
Out there.
Yes, there's fucking legends everywhere. Shout out to all you guys watching. You're the real fucking legends. We're just a bunch of people on the internet reading some cool stuff so we could share it with you, and that way everyone can have this same good stuff. Next, we've got a 5555 super chat from Robert Online. Appreciate everyone's contribution to this community. We are winning. That's right, fantastic. Thank you so much, Robert. It was great to meet you, broski. I loved hanging out with you over in New York City, Brooklyn, all the good stuff. I wish we could have, I wish I could have made that glass tour. You guys look like you had a lot of fun there, but let me tell you, I was tired as shit that day and I needed to go home. So thank you for everything that you did, Robert. You're a fucking fantastic person, and everybody should be friends with Robert. If you're not already, go check him out, Robert Online. And then our final chat shout out, we've got Fox Mulder. As a lawyer, I am not offended at all. I'm glad to hear it, Mr. Fox Mulder. I'm not trying to offend you. I'm trying to say that everyone's job is to do their job, to figure out where they push the buttons to make things happen. And lawyers do stuff sometimes. And now I got to toss it over to AWildSJ up yonder, who has to take off very soon. SJ, final thoughts. Where can the folks find you? Let's have some commentary and, what's going on?
Yeah, so sorry I can't say much of the commentary because there really is just like so much to say and a lot to unpack in terms of, a lot of the different things here. Like the part about asking about the galley, I think I had misheard that in the courtroom and thought that like she was asking to ask us, but so either way, like it was just, it's nice to have the transcript. It's awesome to be able to go back through it, you know, kind of with a fine tooth comb and be like, oh, did I hear that correctly? Is that the way that actually went, you know? So I'm really glad that we did this. And as someone who has, you know, a history with doing audible things, I think that having this is going to be really great for a lot of people that, you know, either weren't going to take the time, don't enjoy reading, things like that. So shout out to everyone on the replay and anyone who this is really going to help, you know, benefit. You know, it comes down to the judge, right? And what at the end of the day, you know, what it is that she's going to say about this whole thing. However, I have to just encourage everyone and just really let you guys know that, you know, the sentiment, the things that I've seen over the last few years, the way that this went, and the absolute, like, the way that the community came together for this, right? I know for a fact that not everybody in that courtroom sitting there to support Richard Hart necessarily supports or loves one another, right? Like, yeah, like in person, you know, it's all, you know, giggles and we're all fine. And at the end of the day, we are all friends. It's fine, you know, but, you know, there's a little bit of war here and there, a little bit of, you know, people poking fun at one another and things like that. But let me tell you, it comes down to the fact that we are all here for something greater than ourselves. And I think that's what draws many people to Hex and what drew many people to Richard. And the fact that he is fighting this, that he decided to take the time, money, resources, and effort to really fight for our rights as investors and as crypto advocates and as people who want to see financial freedom through this blockchain technology, right? There's no greater feeling to me than what we experienced, you know, watching that happen in the courtroom and being there together with one another. So I'm hopeful that all that to say, I hope that other people hear this and also get that feeling of bullishness, right? Like of positivity, of knowing that at the end of the day, we have already won because we have Richard and we're in his corner and he's in ours. And that's something that I've personally felt this entire time, right? Like I've always, because of my work on Sci-Vive and, you know, because of just who I see Richard is as a human being and what it is that he wants to make happen in the world, there's nothing that I think can stop this man. So I'm really excited to be on Team Win. I'm so glad to be on this Team Win with the likes of y'all, right? And people that are out there supporting this message and getting the word out. You know, where can people find me? Mentioned at the beginning of the stream, and I'll mention it again, pulsechaintour.com. You have got 9 days, I think, left to use the code Degen for 20% off. The 20% off will go away after that. It'll be less and less as we continue to get closer to that event. And let me tell you all, this event, because of the way that, you know, what we've done over the last couple of years as a team for the Pulsechain Tour and how we've seen things work and not work and going to other conventions to do research and things like that, this is going to blow everything else that we've done so far out of the water. If you have enjoyed any of our events, this is taking it to the next level. And I tell you what, I think around that time, you know, like I have a good feeling about where things are going to be, you know, like everything's moving in the right direction now, right? So just kind of think about come March, like what all that's going to look like and how we're going to be able to get together. Because even, let's say everything kind of stayed the same. Let's just say it stayed the same. I still want to celebrate. I still want to see all y'all and get together and have a grand old time. So let's go do that. Pulsechaintour.com, 369 conference, March 6th through the 9th in Las Vegas. Again, you got that banner going on down there. Use that Degen code for sure. And then let's just continue to build, right? Because that's what we're here to do, is to build on Pulsechain, to build each other up. And in my case, to keep building up positivity in this world, because, you know, it's just, to me, it's what matters at the end of the day, right? You got a smile on your face, you got a song in your heart. Let's fucking go.
Hell yeah. I love it. Well, thank you for joining us, SJ.
Yeah.
It's been an absolute pleasure.
For everything. Like, seriously, I super appreciate everything that you all do. I can't say enough great things about the Degen Roundtable in general. Miss Producer, my love to you and for everything that you do for all of us. And I'll see you guys on the next one. Have a good rest of your day. Stay tuned
Adios.
to these guys and all their brilliance, and I'll catch you later.
See you,
Excellent.
SJ.
Excellent. All righty. Let's what are your thoughts on the whole thing, Zenith? And actually also Mrs. Producer, if you wanna pipe in as well, we'd love to hear your commentary also. Either or.
I think it was definitely useful hearing it back a second time out loud in my head, because like SJ said, I think when you're watching it live, we were all just like furiously taking notes, trying to like watch what's going on, write things down, try to understand what's going on, and you don't remember everything perfectly. So reading it back was really entertaining. We got a better, crisper view of some of those good quips and lines. Like the favorite one is that, Your Honor, I don't think there's much meat on the bone, and frankly, I don't even think there is a bone, and stuff like that. It's like, it's good to hear it back, but at the same time, seeing the arguments for what they were, and I think a lot of people in the audience were seeing it as well, which is that whenever you were reading the SEC lines, it felt very much like diversion and a distraction and kind of just like meandering all over the place. And then SJ as the judge, or Judge Carol Amon, was trying to really just corral it towards her questions, because at the end of the day, it is her courthouse, or it is her courtroom. What she says goes, and she's the one that directs it. So when the SEC was kind of meandering, she brought it back. At the same time, she did have some disagreements with Richard Hart's legal team, specifically surrounding the Howey stuff and the idea of you don't even have to get to Howey because there's no investment contract to begin with. So it's not like she was fully siding with Richard Hart's legal team, but at the same time, I think it's very clear that the SEC was doing a lot more explaining and clarification, and Richard Hart's legal team was more of just presenting.
Yep. Mrs. Producer, did you have any thoughts that you wanted to weigh in on the second reading? Was there anything that stood out to you a little bit more so than the others? There's also a question in the chats that I want to scroll over to whenever we get a second. But if I see you come off of mute, Mrs. Producer, then I will toss it on over your way.
No, I mostly put myself here as a placeholder since SJ was gone. But I agree with kind of what she was saying. You guys going through it again helped me kind of notice some of the things I hadn't really heard or like gotten, hadn't really clicked in my head the first time. This judge was fantastic, and like that's what we were all saying when we got out of the court. And I just really want to drive that home because she did amazing. The questions she asked were just so on point. And I mean, Will, you did a fantastic job of imitating the SEC with all those just kind of like pauses and like awkward moments, because it is exactly how they were in person.
That's part of the reason I wanted to do it, and why I wanted Zenith to do the Richard Hart lawyers, is because I know that he'd do a better job of sounding like factual and consistent and whatnot, and I could do a better job of faking to be an idiot, or well, maybe not faking.
You're faking. You're not an idiot.
But yeah, so anybody who wasn't there, these guys did a fantastic portrayal. SJ was like right on point, like so
SJ
close.
killed it.
Yeah, she was so close to how the judge was in real life. Like just, it was amazing. You guys did great. And,
thank you so much.
Yeah, that's all I got. I'm gonna go continue on with my background stuff.
Awesome.
Perfect.
Going to go ahead. I've spoken my piece a few times. I'll go ahead and say again that I thought it was just so fun. I focused more on the vibes of the room than on the actual the legal arguments, and going through it a second time, like realizing where in the conversation was the where the there's no meat on the bone, and then also he can spend his money however he wants or whatever the hell, he doesn't owe you guys anything. I had never thought about that before. Okay, so what if he did spend the money? That thought had never occurred to me. And then the whole the bit about them. Oh shoot, what was the what damn it, when oh man, there was another point where there was the meat on the bone one. There was the judge saying, so what if he spends the money? Oh yeah. And then they're like, hey, we're amending this brief in real time. What the fuck's up with that, judgy judge? So, or not judgy judge, what the hell, Mr. SEC lawyers, you guys can't do this. We can't be literally updating the complaint in real time. And then the judge shutting him down when he's like, I'd like to see a show of hands from the audience. And it's like, shut the fuck up,
I'd like
bitch.
not to.
Yeah, I'd just as soon not. That was such a polite way of saying go fuck yourself. That's how I saw it. So we've got some comments from
We got
the
some good
folks
questions and comments
yeah,
as well. Yeah.
some questions from the folks at home. Oh shoot, there was one.
Let's take
Mr. Beyond All.
Yeah, Beyond All is a good one.
Yes. So the only thing I heard that it got covered, or the only thing I heard it got the judge concerned, was why would anyone give money away for nothing kind of line? What did you guys think she ended up? What did you guys think she ended up understanding about the sacrifice for freedom? So I don't like, as far as the question goes. The Richard Hart team did a good job of presenting it like this isn't necessarily relevant to the case at hand, and even though we might not do it, this is something that other people could do. So I really hope that she understood that it's like, hey, these are guys that are basically just making political statements, and that's a sentiment that I agree with. As far as did she understand it or not, I think she probably did. She was really confident in all the other things. So this might have just been a perspective question. What are your thoughts, Zenith?
I agree with Beyond All on this one, which is that I remember this the day of. It was one of the big takeaways that I had, which is that specifically when it comes to the fraud case, it really centered around the idea that people are trying to read between the lines or believe that there is an inference beyond what is said. And this is part of that, which is it's the idea of why would anyone just sacrifice money for freedom of speech? I think it's a new way to do it, which is why it's novel and seems a bit odd. But at the end of the day, you could theoretically call it like a political contribution if you're contributing to a political movement, which this was proclaiming to be. The reason that I think they are highlighting the fact that they believe that there is some sort of inference beyond what was said is based on the October statement, which they covered, which is Richard Hart saying, like, lucky you, there just so happens to be a billionaire who made a thing, who wants to reward people who sacrifice for political speech. But I think Beyond All hit it on the head here, which is that, A, the SEC just straight up doesn't believe Richard Hart disclaimers and like the language that he says, and then at the same time everyone's contemplating like why would people sacrifice for freedom of speech. I don't know if it's actually relevant or not. We talked about it a little bit at the Pulsechain conference, but Access Alive actually made a really good argument here, which is that assuming that this line of thinking is correct, which is that if people are not able to sacrifice for freedom of speech and there has to be something else going on, what that actually does is it takes agency away from the people sacrificing the funds, which means that it proposes the idea that you as an individual are not able to do what you want with your money. Like if you want to go fill the bathtub with dollar bills and Scrooge McDuck swim around in it, like you should have the ability to do so. And you don't have to explain it to anybody. It's kind of the same thing here, but like less extreme, which is that like, can I go sacrifice money and do a show of wealth? Oh gosh, it was the book promoted by Michael Sartain, the Very Important People one. It's this like old Indian tribe ritual where they destroy a bunch of property or they give away a bunch of like stuff to everyone as like a show of wealth from a warlord. I forget the technical term for it, but it's similar to that idea, which is like the point is to display power through sacrificing things that other people find scarce, which is that look at all this money. We sacrificed it for freedom of speech, which is like all of us are showing that we have the ability to do a thing and we're happy parting with our money to make a stand, to show something. Whether or not other people agree with it or not, the fact is you still did it and you had the ability and the ability to do it regardless of your incentive. I do think it does get kind of iffy with like the other half of it though, which is the airdrop. But at the same time, everything with the airdrop was designed to work out well, which was that it's specifically designed to avoid securities law, or not avoid, but comply with, which is that you sacrificed for points. The points later got turned into an airdrop of a token that had no monetary value, zero, zip, zilch. Remember, when Pulsechain was launched, everything on that chain was just merely a copy of data from other places. There was no bridge, there were no exchanges trading for US dollars or anything correlated in US dollars. It merely was ratio trading for these worthless assets, and then eventually it got opened up, and then people were willing to pay money to get these things that were previously worthless. So theoretically, it should be like two steps of separation there, which is that A, you're sacrificing for freedom of speech and freedom of movement. B, you got points, which no monetary value. You just got ranked on a leaderboard for how cool you were for sacrificing for this political movement. And then after that, some rich guy later decided, this is a cool group of people. I built a thing. I want to reward these people because I agree with their values. And then even then, the thing that he rewarded them with was essentially just more internet points until it later became correlated to things that were traded for US dollars through exchanges.
Okie dokie. Excellent.
It was a long
Man,
one, sorry.
I got a little bit lost in there. Are there any other questions from the audience that you wish to address, or any points that were made perhaps?
Yes, there is a point from the Coin Critic. He says, I liked the way the Richard Hart team preempted the jurisdiction argument of the SEC. The location of the server mattered in the other cases. Now they were going to argue the opposite. Then they did just that. Exactly. This was another one of the main takeaways, which is that there is this one, and there's another point which was presented about the jurisdiction, which was that the SEC actually was the one that brought cases, like multiple cases previously, and they were happy because the cases worked out in their favor, which was that they were given jurisdiction over the offerer's location, not the purchaser's location. But now, like I said, now that the shoe's on the other foot, it seems like you're trying to have it both ways, which is that now you're trying to switch up the rule entirely, and you're trying to claim jurisdiction over based on the purchaser instead of the offerer, even though the offerer is the one that was solidified as case law. This is a very good point. But yeah, I agree with the Richard Hart legal team and the way that they... Sorry, I don't agree with, but I appreciate the way that they laid out their arguments, which is everything had reference and some sort of foundation. And I know, Will, you mentioned it earlier, which is you believe that legal counsels in front of a judge is twisting previous case law to fit their narrative, but I would argue it's more of... It's also slightly cynical, but it's more of cherry-picking logical arguments to construct a new logical argument. It is, you have an entire previous library of case law. And there are arguments that are presented before courts. They are accepted. They are denied. They either have stipulations or they don't, or they're general. What you as a lawyer do is you construct legal arguments based around your situation, trying to pull things that you think are relevant from previous ones to prove your case. And I think that's what the Richard Hart legal team did. They cited a lot of case law. They cited case law where it worked for them, where it actually worked against the SEC, sometimes by the SEC's own hand previously. And what I remember when we were doing the old 6-hour live stream reading the documents, the main takeaway was Richard Hart's legal team was very specific. They were pointed, and like you saw with the timeline too, they're very specific with the timeline and the offering periods. Meanwhile, the SEC is very wide swath, just claiming blanket jurisdiction, just trying to wrap everything up in a single package and not try to dissect it. But what you saw in the very beginning was even the judge was trying to dissect things into individual cases, especially for jurisdiction. Which is that this is a notice from RG3, which is that the later you go on in the transcript, Hex actually drops off entirely, which is that the Hex offering is talked about initially for maybe the first half hour, 45 minutes. But then after that, they focus squarely on Pulsechain and PulseX, and Hex kind of just goes by the wayside because they realize it was less material to the things that were being alleged, specifically when it came to the fraud claim. The fraud claim to me, I thought was one of the flimsier parts, but at the same time, I understand why they're focusing on it, because fraud is one of the chief things that the SEC is supposed to prevent against, that and manipulation of markets. But this is not manipulating a market, it's creating a market, and they're just unhappy that it's a global market, by the way. But yeah, again, the fraud idea, it goes back to another point that was raised, which is that even Judge Amon at one point was like, what does it matter if Richard Hart takes that money? Is he not able to? If he was able to take it to develop Pulsechain, why is he not able to do whatever he wants with the money? It's it's either his or it's not.
I agree, and man, I'll say it again. That part of the argument just totally threw me for a loop, because I did not expect that to ever be brought up and be oh wow, what if he did take the money? So what? Cool beans. There's still a fucking 10,000x for Hex, and Pulsechain was still built. It was still launched. Everyone still got all their stuff. There's product market fit. People might not like the price action, but they got everything that even if it was some sort of security or some sort of offering or something like that, he did the stuff that they alleged that he said that he was going to do. So we all know that Richard doesn't owe us anything. We burned our money up to well, I say we respectively. This all happened before I ever joined the the Pulsechain or the Hex world, but like the sacrifices were over long before I was ever around. So as far as like the like people sacrifice their money to make a political statement being in support of freedom of speech and freedom of movement. So like we weren't buying tokens. We weren't doing other things. It's like cool for you guys for getting all that stuff. So that was an excellent point. There's one last question in regards to the redirection of the jurisdiction issue to where Richard Hart resides by his attorney. It sounded like they were kind of redirecting it to Finland for any fraud or illegality. It did kind of sound like that, but the point of that one, as best I understand it, is that like they were saying like, look, you guys have talked about him being in Finland. You haven't talked about him being in the United States. So I think that the Finland stuff was just to prove the fact that like they did a terrible job of arguing the points and everything of that nature. So I don't know. What were your thoughts on that, Z?
There are 2 points when it comes to Finland in this case. The first off is the geographic location, which is that Richard Hart and all the activities he did, whether streaming, building blockchain, promoting it, whatever, was all done in Finland. So geographically, it's not in the United States. He is the offerer. Therefore, if the offerer is not in the United States, theoretically, they don't have jurisdiction. Additionally, the second point is that when it comes to Finland, Finland has its own regulatory authorities for this exact kind of thing. So if he is doing things in a jurisdiction that is claimed by another interest, which the U.S. does recognize, by the way, which it means that they have a jurisdiction that is their own, that is not the SEC. So why is the SEC going into someone else's jurisdiction to get their thing? Based on everything going on, it's like if there is actual illegality going on, Finland is the one responsible for prosecuting it or bringing it to light, as opposed to the SEC for trying to drag their citizen from their country operating in their territory to U.S. law, as opposed to operating in Finnish law.
Yep. Sami made a very good analogy on this the other day. And shout out to your friend Sami. But he had said like it's like the SEC is the teacher in a classroom, and the person they're alleging is doing a bad thing is a student from another school, and they're in a different place. Like, does the teacher have the right to go over to the other place and find that student that did a thing and then say, you're going into detention in my school, or like you're going to get a slap on the wrist or whatever? So I think that was a super good analogy, and that was the whole purpose of them talking about Finland. I think is like whether Richard Hart actually lives in Finland or not. They're alleging that he lives in Finland, and they're alleging all of these things so that like it kind of discredits the argument about the U.S. having jurisdiction and specifically the SEC having jurisdiction. So that was an excellent point as well.
The only final points I got for you on this are,
go ahead.
Remember, folks, this is a civil case. This is not a criminal case. So any penalties here are going to be pretty much monetary, or just be like, hey, stop doing that thing, or any money that you got out of this, like give it back or get rid of it. And then additionally, this was a hearing on the motion to dismiss. This was not a trial. This was merely oral arguments, a.k.a. Richard Hart's legal team and the SEC both wrote briefs. We read them live. They submitted them to the judge. This was a time for the judge to ask questions that she did not have good answers to. So when you heard the Richard Hart legal team talking about, like, it sounds like you're amending this in real time. Like, all these things are not the original argument or the original complaint. What they're saying is that they're referencing the fact that the SEC is trying to bring up stuff on the fly as opposed to their previous charges or the previous complaints that they had. So what the motion to dismiss is supposed to do at this point in the game is to determine whether or not the SEC even has a legitimate case. And they're not trying to argue over facts. That, again, goes to one of the points they talked about, which is like Richard Hart's legal team was like, look, we're not trying to argue the Howey test, even though we disagree with like previous case law, because that's not appropriate at this time. What is appropriate at this time is trying to look at what they're alleging and what they've presented to back it, and determine if there is enough to back it to make it worthwhile of the court to use taxpayer dollars, time and effort and energy to pursue this as opposed to anything else. So with that being said, even the conclusion of this, it's not going to be that fast. Oral arguments happened on the 31st of October. We're probably going to see something within 2 months, aka before 2024 is over. And it's going to be something for the judge, whether the motion to dismiss is either granted, partially granted, or denied. One of the things you heard early on was the idea that the SEC was dropping the alter egos theory. So that's something that's more than likely going to be dismissed partially. But then the other question is, if they lack jurisdiction, or if they lack proof showing that there actually is a domestic securities transaction that they're trying to pursue. If they fail on either of those things, the entire thing could theoretically go up in smoke, and the motion to dismiss would be granted entirely.
Mm-hmm. It's some good stuff going on there. We've also got another comment from Coin Critic just came in, Mrs. Producer, if you wouldn't mind pulling up. They were pointing out that the Binance case was a different situation. In Binance, the defendant was citing they were not under anyone's jurisdiction. In this case, RH is not claiming that here. RH doesn't claim anything about we don't belong to anyone. He's also not saying we do belong to someone. He's just not saying anything at all. So that is an excellent point, Mr. Coin Critic. Well said there.
True. To double down on Coin Critic's point as well, there's another half of that, which is that in the Binance case, they were specifically suing Binance. They're not suing CZ. They're suing Binance, the company, the LLC, the corp, the whatever
Exchange,
the legal formation is. What that is a legal entity, not a person. In this case, it even goes one step further because they're suing a person. They're suing flesh and blood. They're suing Richard Hart. Binance may not have a physical location because you can't put it in a physical location because it's an idea. It's a legal entity. Richard Hart is a physical thing that has a physical space that occupies space and time. So you can absolutely pinpoint him to a location. Happens to be Finland.
Yes. Ooh, that's a good point. Yeah, there you go. I like it. Well said by everyone. We've got
Excellent
one
comments.
final chat shout out for the folks at home before we start going through some of the fun and fancy pictures, and then we'll go ahead and wrap the show up and get on with our merry lives. So, Mrs. Producer, if you wouldn't mind pulling up Mr. Chad Donnerschwanz. Hello, fellow based crypto bros. Good to see you, amigo.
Based. Welcome.
With his Hexagon space frogman that's ripped and shit. Love to see it. All right. So that concludes our fun and fancy show. Mrs. Producer, if you don't mind pulling up screen share again, I'm going to go through some awesome photos. So for the folks at home, we were talking a lot about the timeline document. So this is the alleged timeline that the SEC had produced. So the SEC's alleged timeline. So December 3rd of 2019. This is what Richard Hart's lawyers brought, and they presented this. This is actually a picture that I took. You can see where the little easel is up on top and the stuff on bottom. But like, this is the stuff that they were talking about like during the actual court case. So like they were literally pointing to this thing in front of the judge, and it was so fucking funny because like I said this earlier in another stream before, but imagine that my head is Judge Carroll. On this side over here, on camera left, we have the SEC lawyers. On camera right, we have the Richard Hart lawyers. The Richard Hart lawyers took this piece of paper, and like if you imagine, like each of them is respectively like this. They took this this poster right here. They set it up right in here between them and the judge, and they angled it in such a. Let me see if I could do it for the camera. There we go. They angled it. There we go. In such a way. Damn it. Which way would I have to do it? I have to do it this way. They angled it in such a way that the SEC could not see what was on the poster that they were referencing is like of their like this timeline that the SEC is claiming everything that happened. So this shows all of the stuff that's happening and gives the judge like an idea of everything in its entirety. So it talks about like the December 3rd, Hex was published. This is the Hex adoption amplifier period throughout most of 2020. And then November of 2020, Hex is no longer available via the Hex software. So like this is when like all of the like real beginnings of Hex started, and you could no longer like trade in stuff to get it off of the closed market. And then there's the Pulsechain sacrifice here in purple. And then it was unofficially extended over to here where Richard Hart honored a lot of the people's money that was sent into the sacrifice wallets, even though he didn't have to. He said, hey guys, the timeline ended, back here on August 3rd, but
Will, you cut out there? Let me
All right.
bring you back.
Oh, I'm back now. Go ahead.
All right, do it.
Okay. I don't know where I left off at. So
pretty much top line of let's go to this. Top line of the diagram is pretty much everything that Richard Hart's team was referencing, and then the three red points down at the bottom. Those are the items that SEC's legal team is referencing as evidence of trying to impact the offers that very clearly happened before they were made. So this is just one of how they clarified that, being like, look, all this stuff is over here. Everything that was said that you claimed to affect this stuff in the past happened well after.
Yep. So basically, they're saying like they were trying to present the bottom information as stuff that happened during the top time in order to affect the price and encourage people to engage in unregistered security and all that. So anyways, not only is it like a silly claim, but it's also totally bogus and like not in tune with reality. So that's that little picture. That's a fun one. Up next, this is all of us in front of the SEC, the United States Courthouse. So there's 76 of us in this picture, I believe. There were 76 of us in the courthouse. So we've got Rob. There's people here all over the place. There's SJ.
People.
Yeah. I was about to say there's SJ right there. There's RG3. You can see me hanging out right there. Matty Allen's over here. Where are you at, Zenith? Where were
do you see the guy in the blue jacket on the right side?
This guy right here. Oh, is that you?
Yep, that's me wearing a tie.
Excellent. And then also over here is Flat Earth Dave. He was super cool and he was hanging out as well. You guys can't see these individual signs up here, but it was super fun. Gensler Hertz Investors, we support Richard Hart. SEC, man, I have a better picture of that somewhere. Let me see about this one over here. Okay, this is another one. Support Richard Hart. Gensler Hertz Investors. Yep, there's Crypto Coffee. Don't let the SEC kill crypto. There's beautiful Zenith right there. Is excellent. Such a good time. You guys might recognize some other folks over there. Another picture, SJ holding up, we support Richard Hart, Gensler Hurt Investors. Aha, here's a good sign of a good rendition of the red sign. The SEC steals everyone's crypto. I thought that was fucking brilliant. They did a very good job putting that one together. So there's another little photo there. Here's some images of us signing the petition. Everyone signed the back, or excuse me, not the petition. Everyone signed the back of this document right here, and that was gifted to RG3. So there's some pictures of folks signing it. There's our beloved Mr. Nate McGettit, the Ascending Man, signing it. Super awesome. Here's a bunch of the pizzas that I ordered. This is super cool. I ordered these pizzas and RG3 paid for them. We had so much fucking pizza, man. The dude that brought this shit to us, he carted it like about 3/4 of a mile on basically a Costco shopping cart out to us from the pizza shop. So it was super cool, man. Shout out to Pizzetta from Brooklyn, New York. Those guys were freaking awesome. And some more photos. We stayed at this park until pretty much nighttime. We were there since the SEC hearing was at 2 p.m. I arrived here at I think 8 o'clock or 9 o'clock in the morning or some shit, but we stayed there long afterwards. And then here's a single picture of the Pulsechain tour with all of us. RG3 holding up his little poster thing. Everyone standing here looking beautiful, having fun, doing a lot of cool stuff. So that is all that I've got for the screen share and all of the fun stuff. So Mrs. Producer, I'm gonna go ahead and finish off the screen share there. And that's all that I got. Zenith, any final thoughts before we do closeout stuff?
Sure thing. You forgot to mention that the reason we stayed at the park so long, not just because you ordered pizza, but because I was live streaming from a park bench with RH Max over on his channel. So if you want to go check out our initial reactions, we had a fun rotating carousel of guests coming through the park bench. I think we had Coffee, SJ, Will, you were there for a bit, and then we had a good section with RG3. So that's over on Richard Hart, RH Max's channel. Go check it out. That was a fun stream. But other than that, I think I said it on RH Max's stream. Someone asked, do you think we're going to win? And I said, no, we are winning. We're actively winning. It's happening right now in real time, and we just saw it in a courtroom. I think it's more so, especially today. I know we're not trying to get too political, especially on this stream, but fair warning, I might do a little celebration on the Whiskey Wednesday tonight. But I think that with Donald Trump getting elected, the crypto industry feels a lot safer in those hands as opposed to the potential Harris administration. So things are actively shifting. Things are moving, and it's very obvious by Bitcoin literally being at all-time highs right now. I'm looking at it, $75,720 today is currently pumping. It's quite a time, and I made this joke on Corey Costa's stream earlier. I said, great day to be a Hexagon, and I said, spoiler, it's always a good day to be a Hexagon.
It is always a good day to be a Hexagon. Fantastic.
Other than that, folks, we have Whiskey Wednesday going on tonight, so come hang out. It is our version. We like to pay homage, although they say that what is it? Imitation is the highest form of flattery. So I'm not saying we ripped off the effing Hangout from RG3 and SJ, but we're doing something similar tonight. So if you want to come hang out, jump on stream, jump on StreamYard with us, celebrate, bring up any questions, any ideas. I know some of the team has some deep topics they want to talk about for the first hour before we get all the boys on. So we'll talk about that. And then other than that, we have book club this Friday presented by yours truly. Should I don't have my book with me, but we're doing The Great Wave by David Hackett Fisher. It is a recommendation that I got from the What If Alt His channel, aka Rudyard Lynch, the guy that runs that. I think he's a real sharp guy. And this book specifically talks about the cycles of inflation throughout history, not just the last 20 years, the last 2,000 years, and how there's cycles of inflation and deflation, and how it signals changing times. So that's what we got. Other than that, big flagship show on Sunday. We're going to be talking about everything. I'm sure the market's going to do even more unsuspecting things in the next 3 days. So we'll talk all about that on Sunday. So show up for our standard segment there, and we're going to get as many of the Degens to the roundtable as we possibly can. Other than that, folks, you can find me on Instagram and Twitter at ZenithDI. If you have any questions, you can hit me up on there, or you can go into our Telegram and at any of us on the team or anybody in the community, and we'll try to get back to you as soon as we can and share some good research and conversation in there. Other than that, though, folks, that is all I got. Will, please take it away, sir.
Yes, for the folks at home who Zenith's covered everything for the schedule. You guys can find me, all of my socials at will.pls.fyi. I'm starting to become more active on Twitter, so I'm posting my Twitter down in the description below, along with Zenith's. You can just find me on Twitter at Will Stevenson X. And I think that's all I got. I'll see you guys on this. Oh, what you got?
Real quick, folks, don't forget, you got 9 more days if you want to use code Degen to get your Pulsechain Tour Vegas tickets. I was informed by Pulsechain Tour Live in the comments that we are currently in a run and gun battle with Access Alive for whose code is selling the most tickets. So please, help us win. We want to do all of the winning. Got to be number one over here. So use code Degen at checkout, get 20% off your Pulsechain Tour Vegas tickets. That's March 6th through the 9th. I'm going. Will's going. A bunch of other people are going. I do believe this is the premier Hexagon event of the year. So if you want to meet folks, hang out, just play around in Vegas, or if you actually want to come shake hands with us or give us crap for not being able to talk properly on microphones, then that's the place to do it. So that is all I got. Will.
Excellent. I was saying where the folks can find me, what's going on in the near future. If you guys are Hexicans, this is the other thing that I'm going to shout out, is if you guys are Hexicans, you want to meet other Hexicans, you need to go to the Pulsechain Tour 369. And aside from that, you need to go meet other Hexicans in the real life flesh at bit.ly/hex_meetup. That's the best place to start your own little meetups, to go see what other people are doing with all their other little meetups going on. Basically, just tag along and hang out with any Hexican anywhere in the world. So I'm going to go ahead and drop the link for that in the chats below. Again, it is bit.ly/hex_meetup. You could also do t.me/hex_meetup. It'll take you to the same place. The bit.ly, though, will put you right at the start here message, which is the best place to start. Other than that, I think it's time to read the end of the show copywriting. So let me go ahead and pull that up. Oh, I've lost my tab. All right, there we go. I want to thank you all for spending your valuable time with us here on the Degen Roundtable. As Agent J often says, we know that time is your most precious asset, and we appreciate you investing it right here with us. Ladies and gentlemen, my name is Will Stevenson, but more importantly, you have been watching the Degen Roundtable. Mrs. Producer, go ahead and get that trigger figure ready, because it's time to remind all the folks at home to remember to Degen responsibly.
Ladies and gentlemen, welcome back to the Pulsechain Tour Masters Golf Tournament 2024. Zenith is making his approach to the green on this sudden death playoff between himself and Reginald Gerald III, who already completed his putt for birdie. Zenith needs to make this putt right here in order for his dreams of winning that jacket to stay alive. Let's see what he does. Oh, he flubbed it. He missed. He whiffed. He's a loser. I repeat, RG3 wins. RG3 wins. Don't make mistakes like that guy. Get ready early for Pulsechain Tour Las Vegas 2025, including the Pulse Masters Golf Tournament from March 6th through the 9th. Sign up early and use the code DGEN at checkout before September 1st to get 36.9% off all of your tickets. Don't miss out on all the fun from the star-studded conferences, golf tournament, and nightly events in beautiful Las Vegas, Nevada with all of your friends and favorite Pulse and Hex creators. We cannot wait to see you in Vegas, so until then, Degen responsibly.